Thank you all for spending your morning with us. I'm going to go over a class on board member best practices, and we're going to focus solely on board meetings today. Why are we doing that? We're doing that because a board meeting is the most public display of what you do as a board member. No matter how organized you are behind the scenes, if you show up and you run a dysfunctional board meeting, you're going to lose the support of your community, potentially your fellow board members. We have our attorneys here today. I won't be answering any questions regarding legal advice. That's what they're here for. They're going to give a full course on that, and there'll be plenty of free legal advice at the end of it. So we'll save those questions until the end. I will take some questions along the way. I got to be careful not to let any one person dominate the questioning too much, and let's try to avoid really unique property-specific questions. I'll be here after the program. I'll take as many as you want outside of the presentation, but we need to try to move through it a little bit. So what's our goal? Our goal is to try to make you as effective and efficient as possible running your board meetings. Hopefully you pick up one or two tips today that help you become a better board member. So let me just do a quick show of hands. How many people here, this is their first time elected to their board? Okay, a few of those. How many 1 to 5 years on your board of directors? A few, all right. How many 6 to 10 years on their board of directors? Pretty good. How many over 10 years? 2. All right.
Is that legal?
Depends who you ask. We're going to save that for the attorneys.
She was the past president. She gets to make her own rules.
There's some debate on that. But my associate Diego has some gavels for you. The three, I think 2 or 3 of you who said over 10 years. So we'll make sure we give you guys some gavels as parting gift today for your service. Thank you for your decade of service on your board. All right. So let me get some input. What do you think would define a bad board meeting? What are some of the characteristics of a bad board meeting? Fighting, yes, I've seen that. That's a bad board meeting. Any other characteristics of a bad board meeting?
The president making an own decision without the board.
If the president is not taking votes, that's a bad board meeting. You talk to your attorney, yes. Yes, ma'am.
It's not publicized.
Not posted for the notice requirements, I would agree.
People.
I wouldn't go so far as saying not enough people. If you don't have a quorum, that's bad. But if you have, sometimes, I tell a lot of boards this, people say, well, there's just no one coming to the board meetings and this is a big problem. And I say, not necessarily. That is often a show of support. The community thinks it's being run well. They don't need to come there and micromanage and ask 100 questions and bother the board. I mean, it's a vote of confidence when you don't have a huge turnout at your board meeting. So it's not always a bad thing not to have a huge crowd. So do keep that in mind. But yes, a lot of the other things that were discussed, one of them is meetings go too long. How many of you have a board meeting that goes more than 1 hour on a regular basis? How many more than 2 hours on a regular basis? More than 3 hours on a regular basis? I'm not going to stop now. That's way too much. I mean, a good board meeting should really last about an hour. If there's a huge controversial topic on the agenda with professionals and attorneys, obviously that's an exception. But your routine board meetings really should be about an hour long. So we're going to help you hopefully get some ideas how to shorten your board meetings if they are taking too long. So how are we going to do that? We came up with 9 steps to an effective board meeting. How did we come up with these? These aren't my ideas. These aren't Gary's ideas. Campbell Property Management has over 130 licensed camps on staff. Probably an average of about 10 years of experience. We bring them all in for training 4 times a year. We sit them at round tables and we like to do some discussions. And one of our discussions was we asked all of them as a group to kind of give us all of their best practices for how to conduct a board meeting. And with their combined 1,000 years of experience, we came up with these next 9 ideas. So, what are they? It's going to be preparation, have the right equipment, establish your time limits, declare the ground rules, the agenda, member speaking, Robert's rules, within reason, don't criticize, and we're going to talk about your minutes. So not only are we having this presentation today, but we have actually written this up as a blog post in some more detail. You can find that on Florida Association News. That's a website, a blog that Campbell publishes, and you can sign up for it and get it in your email, or you can just read it online. And we're constantly publicizing blog articles and newsletters from other industry professionals like law firms, like CPAs, like contractors and vendors in our industry. It's all very specific information to condominiums and HOAs in Florida. So if you want to subscribe to our blog, it's readfan.org. So you'll get constant updates about things as they change in our industry, including legal updates, different things like that. So preparation. What's the most important part of being prepared for a board meeting? It's going to be your agenda. What do you want to put on the agenda? Only the items that you're actually prepared to act on. You want to understand all the issues on the agenda and be prepared to articulate your position in front of the membership. This is not a time to discover new ideas or debate. If that's on your agenda, you should put that off until you're more prepared to talk about it. How do you get prepared for the items on your agenda? There should be a board package. Your property manager should prepare a package with everything that's on the agenda, all the background information necessary, bid packages, whatever's there to be discussed, and get it to you at least 48 hours in advance, hopefully 72 or more if possible, so that everyone has the time to read and digest the information that's going to be discussed. Some people say, well, how can we get prepared for a board meeting if we're not allowed to meet as a group, as a quorum? What you can do, some associations it works for, others it doesn't, is hold workshop meetings. What a workshop meeting is, you post it, it's a legally noticed meeting, and you tell everyone we're all going to get together and we're going to discuss these topics. We're not going to make any decisions, we're just going to have a discussion, and you can go back and forth and talk about all the different things that may be coming up on the more formal board meeting to be voted on, and you can cover everything you need to talk about in that legally noticed open setting. What else is important? So the right setup and equipment. Who knows the best way to organize the seating for a board meeting? Anyone have any thoughts? Does it sit straight across?
No,
Round.
round,
So,
round or
U
square?
shape, yeah. So in any sort of board meeting format, you want to seat everyone in a U shape if you can. What is the goal of that? The goal of that is to be able to see the other board members that you're talking to and discussing with. Remember, the board meeting is a meeting for the board to conduct the board's business. It is not a meeting for the board to preach at the homeowners. The board has business to conduct. The members are invited to sit there and witness the business of the board. So sit in a configuration that's more conducive to working with your fellow board members because it's very hard to communicate with people when you can't make eye contact, or at least communicate as effectively as you otherwise could. So that's the goal of that. Other issues, if you have a microphone, if you have a large room, or you have soft-speaking board members, make sure you have a microphone, or multiple microphones, so that everyone can be heard. If you have out-of-town board members, make sure you have a good conference line. There's internet services now that you can use for conference calling. There's a lot of different ways to make sure you have an effective method of bringing them in, be it a video conference or telephone conference, and test all your stuff ahead of time so you get to the board meeting, you look professional and prepared. A gavel is a more effective method than screaming at everyone to calm down and getting people to calm down. So try to have a gavel if you don't have one. Establish time limits. So this is very important. Not just time limits for your owners to speak. I think a lot of associations are aware that they can set a time limit on how long owners can speak, but also you may want to put time limits on how long the board can speak on a particular topic, especially if you have a board member who's known to be very long-winded. What's the best way to do this? Anytime you're going to have rules about how to run your board meeting, you want to announce them in advance of the meeting. In fact, it's best if you can even publish them. Some associations will publish the rules and hand them out to everyone as they come into the board meeting. So the last thing you want to do is try to establish a rule after a meeting is starting to go off the rails, because the people who are frustrated are just going to think that that rule is only being established for them. And by then it's way too late to make a rule. So if you want to keep control over your meetings, establish the rules ahead of time. So again, declaring the ground rules, owners have the right to attend, observe, and listen. It doesn't mean they have the right to interrupt. It doesn't mean that they have the right to scream at you, to call you names, etc. You have to keep control over your board meetings. One of the most important So one of the best ways I see of the board communicating with each other and then letting the unit owners also communicate is if you establish rules that when a motion is made, the board will discuss the motion first. Only board members. People can raise their hand, they can tap their foot, they can get really frustrated, they got something they have to say. You don't call it. It's the board's opportunity to talk. All the board members discuss the motion. Then when the board is done discussing the motion, you open up to the owners. So they've heard everything the board thinks and feels about this motion. Then you take questions from the owners. Typically, it's up to 3 minutes per owner if you want to set some rules. And then the board takes their input. The board then has the opportunity either to talk again if they heard some things that made them maybe change their mind, or they may say, thank you all for your input. We've heard enough. It's time to move on to the vote. That way, the board had interrupted discussion on the topic. The owners had an uninterrupted chance to give their thoughts, and then you can either talk again or not and vote. Everyone's been heard, and it's a very formal way to do that. Some boards have success in a more town hall style format where people talk in the middle and you talk, and that can work, but it can also get really unruly, particularly on a controversial topic. So agendas, you have to follow your agendas. In a condo, you actually have to have the item on the agenda for it to be discussed. HOAs have a little more leeway there. It's still not a best practice to discuss something not on the agenda. They'll talk about this more. But condos, if the item's going to be discussed by the board, it should be on the agenda. So be aware of that. Why is that the rule or the law? It's because the reason you have to post the agenda. Why you have to post the agenda so the members can know it's being discussed. The members may be really passionate about service animals and not so passionate about who the next landscaper is going to be. So if they see service animals on the agenda, they're going to be there. And they have the right to be there because they really want to hear that conversation. If they see landscaping, they may not turn out. So that's the whole goal of publishing the agenda and making sure the items are on the agenda so that your members can be at the meetings that they need to be at. And hear the discussion is going on here.
That's okay, they didn't get.
So some places have a little bit of difficulty actually setting the agenda. If that's an issue in your community, we've established policies that the board can bring up as a motion and vote on. You can actually put a policy in for your board as to how the agenda gets set. So if that's an issue, we'll talk about that later. Letting the members speak. So I covered this a little bit earlier with the ground rules, but again, the idea, the members have to have a right to speak on agenda items. Best practice is to require members to sign up and want to speak in advance of the meeting, have a sign-in sheet, have them write their name and the agenda item to be discussed, and that sheet gets turned in the board so you know who to call on when an agenda topic comes up. Again, with the ground rules, the law allows you to limit it to 3 minutes per member, and the members can't all give their time to other members, so one guy gets 60 minutes or something. It's 3 minutes per member. There's no buying or selling of minutes. So be aware of that. But again, you want to do that early on. You want to do that before the meeting starts. And like I said, always let the members talk about the item before it's voted on. No matter how non-controversial you think the item is, or particularly if it is controversial, make sure that the members are heard because they would be furious, regardless of what you do. Even if you made a decision they would have ultimately agreed with, if they didn't have a chance to talk before you vote. So again, if you need a policy, we have policies that we've developed. You can vote into the minutes of your association and make rules for your association regarding how to let members speak at meetings. Oh, I'm sorry. Yes, ma'am.
What about if you put down old business or new business, could that be addressed?
So I think that the attorneys will talk about that. I think what they're going to tell you is that's a little too vague, that you need to be more specific than old business and new business in a condominium. That you have to cite what those issues actually are.
Thank you.
It's a fair, yeah, and generally. Once in a while, I'll have it come up with the DBPR, and it depends on who you get as an investigator. And if the investigator likes you as an association, you're not known as a problem child, they'll say, okay, we'll squeeze this in old business this time, but going forward, make sure that it's more explained. But if you're a chronic offender and you show up on their radar every single month, then they're going to say, no, you have to have it on your agenda going forward.
Yes, sir.
What are the specific rules about workshop meetings?
That's a legal question. We'll hold off for the attorneys on that. But generally, a workshop needs to be a noticed meeting of the board. you're telling the community the board is going to get together as a full board quorum, and they have the right to attend and listen to what you're talking about, but they can get into more detail on that. Workshop is just really a term. It doesn't have any legal meaning. It's still going to be a board meeting that has to be noticed and such. So, Robert's Rules. I think we've all heard of Robert's Rules in some form or fashion. Robert's Rules is not the law, but it is an effective way to help manage your association and manage your board meetings. Robert's Rules tells parliamentary bodies kind of how to function so that motions can be made and passed, discussions can be tabled or postponed, that sort of thing. Try to use it as a guide, use it within reason. Is anyone in here a parliamentarian or has used Robert's Rules at any length in their career?
Put your hand down.
Besides the attorneys in attendance. So we call those in our firm, we call them Robert's Rules ninjas. And yeah. Robert's Rules, I don't know if any of you are familiar with the book. This is Robert's Rules. It's a lot of rules, okay? Someone like Joel, who's an expert, candidly can completely derail a meeting with motions and motions that have discussion, not have discussion, all sorts of things. So we don't have to go by this book. We just have to make motions in seconds and allow discussion, that sort of thing, in HOAs and condos. So do use it as a guide to be organized, but don't get too carried away. Don't let the protocol distract you from the content of the meeting. Some people get hung up in the details, but don't get caught. So sometimes boards are uncomfortable with the parliamentary structure of motions and seconds. Sometimes the issue is very contentious and everyone's so involved in their discussion, no one makes a motion or they just start discussing. If you think you have that issue in your community, ask a property manager. Maybe even ask a volunteer from the community to just be the parliamentarian for the meeting if you don't have a property manager, so that somebody can keep control of what actually needs to be done at this meeting and take the minutes and make the motions and that sort of thing, so that you actually have a legal meeting when you're done with your discussion and you're on track. So, all right. Number 8, don't criticize, condemn, or complain. So it's always a good idea to try and win friends and influence people, especially when they are your neighbors and shareholders. That was Dale Carnegie, for those of you who did not read his book. You always get more bees with honey is another way to explain it. Calling names, criticizing others, telling people that they're thieves, or all the different things I've heard in all these meetings. It's not an effective way to build consensus in your community. Often, we'll see that there's a board sometimes that's split. One group really feels strong about one issue, and the other group feels completely opposite about the same issue. And if you know that meeting is going to be contentious, try to be prepared. Give yourself a little script. Think of some things that you can say that says you politely disagree with the other side, but they're not idiots, they're not stupid, they have no idea what they're doing, that sort of thing. Try to limit that kind of banter, because you're doing it in front of the community, remember. And although you may feel that way personally, you may even be right. It doesn't look good in front of the people. And you're an elected body, you're trying to run a business, you want to look as professional as possible. And that sort of communication just inflames the situation. If it's already contentious, telling someone they're an idiot isn't going to convince them to vote your way. It's just going to make it even harder to get done what you need to get done. So just be aware of that as you're in some of these more difficult meetings. And minutes are not transcripts. If you leave here with one nugget of information today, I would say let it please be this, and I'm sure the attorneys are going to agree with me.
Absolutely.
Minutes are not transcripts. What does that mean? The minutes are not a record for everyone who wasn't in attendance at the board meeting of everything that was said, discussed, kicked around. That is not at all what they are for. Minutes are a legal record of the actions that were taken by the board, who was in attendance, and how they voted. So what does that mean? Your minutes should have who was there, present or not present from the board, the time the meeting was called, the agenda items, and then any motions that were made on those agenda items. All it needs to say is discussion ensued, and then the vote, either unanimous or the vote count, and who voted on either side. That's all that needs to be in your minutes, and then the adjournment of the meeting. Anything more than that is really just probably going to create legal liability for you. Let me tell you a story about a possibly fictional association, possibly not, that I heard about. So there was a HOA that had an intersection that the board considered to be dangerous. They took meeting minutes. The lady from the board was outraged. She said, this intersection is a death trap. What do you think happened within a year of that meeting? What do you think happened to that association? And you think they won or lost? It's all fictional, but let's just say it was extremely fictionally expensive for the association. And that was a smoking gun for a plaintiff's attorney. And it's not that the woman was wrong. The intersection may have been dangerous. But is she an engineer? Is she a traffic, does she do traffic studies? Does she have any professional, background to say that that intersection is dangerous? Not really. But, it still costs dearly in the end. So that's just one major example, but I'm sure you could think of a lot smaller examples in your own association. People have said or done things that may have ended up in the minutes that could really cost your association. So remember, your job isn't to make sure everyone knows what happened at your board meeting. Your job and responsibility is as a fiduciary to your association, and that means keeping the best financial interest of your members in mind, and them losing a massive judgment is not in their best interest. Yes, sir.
Question regarding minutes. So are they supposed to be published immediately after the meeting took place? And who is supposed to take those? Is the board members, is the association, the building management?
Sure. So the secretary of the board, is supposed to take the minutes, unless you have a management contract that says your management company is going to take the minutes.
Okay.
You should only be posting approved minutes. That means minutes that have been, at the next board meeting, have been reviewed by board members, read, any changes, have been made via a motion of the board, and then approved. I know that attorneys will get into this more, so I don't want to go too much more into detail, but you should only be posting approved minutes, and I'm not exactly sure how quickly they post on the website. They'll get into that, because that's a new law. Yes, sir.
Should the minutes of the previous meeting be read at the next meeting? Read to the members of the condominium?
So it's an option to either read them, or you take a motion to waive the reading of the previous meeting's minutes, but they still have to be approved by the board.
And that's, sorry, go ahead. I mean, that's when they become an official record of the association. Once they're ratified, it's an official record, and they're subject to all the other requirements.
Don't you think they should be read in front of the people that are at the meeting?
I politically and as a transparency mechanism for a community, I could completely embrace what you're saying. Legally, there's not an absolute requirement to read it out, but I agree with you. It could be a good practice, especially in a community where there might be some degree of suspicion about transparency, just to be completely above board.
And to build on what Michael was saying, one of my very first association meetings I ever went to as an attorney, this was an association that took transcripts of their minutes at every single meeting. So the first thing they did was read the minutes from the previous meeting. The minutes were an exact transcript of everything that was said verbatim. Then when we got in the part about that meeting, they read in the previous meeting minutes into that meeting minutes, into that meeting minutes. So it just started building on it. So I was there for 45 minutes and we were still reading the minutes from the last meeting. There has to be a little bit of reasonableness when you read the minutes in, maybe just do the high points, make sure that everybody knows this was the issue, not go through every period, semicolon, and comma.
Did you post minutes that are not approved, but say they're not approved?
So let me just stop. We're getting a little bit into the legal advice portion. They're going to spend a lot of time on that, so I'm on just a little bit more on the wrap up. So again, a lot of the resources I talked about, our blog, we have a search engine that only searches through articles written by industry professionals and all that. It's through getfan.org, so if you want to sign up for our newsletter and get monthly updates about this industry from professionals like me, Michael, and others, please go there and sign up for that. And for those of you who are new to the board, we have our board member primer available online. So that's a whole package of documents that we put together that come from the DBPR, that are the Florida statutes, and it kind of teaches you what your responsibilities are legally as a board member. So that's something else that's available on our website, which is campbellmgt.com. So At this point, we're going to actually take a brief, well, first, is there any more questions about the management portion before we get into the legal advice portion? Yes, sir.
In condos that have a CAM, should the CAM participate in the board meetings?
I think so. I mean, every association is different, but in our firm, the CAMs are always participating in the meetings. That doesn't mean that they shouldn't be participating in the discussion on a topic. They shouldn't be giving their opinion of what they think the board should do unless asked, in my opinion. They shouldn't have a personal vested interest in which direction it goes. But they should, when called upon, yes, they should be available to answer questions and give you advice.
I'm not sure what you said. Could an individual request the minutes after the meeting?
Not until they're approved. As Michael said, that they're not.
Any individual could ask for copies?
Absolutely. Any approved minutes in 7 years. Going back 7 years. Down forever. It's going to be harder to go back on. Any other questions? All right. Thank you, everyone. We're going to take a short break to take your lunch orders, because I'm sure everyone wants to order the steak. And get that process started for you.
So stay in your seats, because they're gonna come right in and go right around the table and take your order, okay?
Stay where you're going to sit.
Right where she just walked in, the table is right on the other side of the door, right here. Okay? So, thank you.
So cold.
It's quite all right. Right, she's right outside the door. Thank you.
Hey, I was thinking, because I saw you collide on my voice. Anyhow, I was thinking, I'm gonna ask John and Sherry. I do too. We have to have watch.
So if I go this way, they'll take a right. You're up there on the left-hand side. You're on the side of
They're new. They bought in. They bought in. Yeah, they are. The one that was in the top? Okay. The one How would you name
Are you mad?
Well done. Okay.
But you want the ribbon or you want that coat? I wasn't late, I didn't have some. I'll bring that.
Oh, I wish you did. You know what happened? I had my spare cylinder in the car. I took it out into the house to wash it. Never replaced Yeah, that's what I do. You have to go for it. They don't want to You talk to the car, it's private, it's a common element. You can use it. All you have to do is get it maybe he was right, maybe. And now they don't put the meetings on. If it's a fire, hell no. If it's a flood. Now they're trying to remember at yeah. We've got each building two people are the last person to member of the party. Okay. I'll tell you how to get around that. You write down everything that you want. We have 5 people running here. Your secretary.
Were you one of the women who was born 10 years on the board?
Yes. How about 19?
Well, you got a bigger gap.
Thank you.
Because I live here, I know everyone here in this area, Broward, Palm Beach, and I teach the last part time for all condo. I do project management, and I sit on Tallahassee. So, off the record, I would probably first of all try to get this out before I would call us to show up. I would try to put that. I sit on the board for the Regulatory Council of Association on making recommendations to the Department of Professional Regulation on manager licensure association stuff, guidelines and stuff like that. There's 7 of them that are all appointed at different times by the governor, where the governor is there. And we're all strategically located around the state. I represent South There was an association
Secretary has to do his job. You have to be you have to keep all the records. You have to do the updates. You have to make his job. Unless you're secretary of the state, then they cut you out of everything.
We appreciate you coming. As I said before, we gave you salad, we gave you dessert, and thank you. We took the orders just so you make you really feel good. But we gave, you notice how we gave you dessert now, right? Perfect. I actually, it's actually, if you've eaten here, it's very good. I actually prefer, I'm one of those guys that I would actually prefer to eat dessert first and then decide whether I want to order or not. But look, my former president right here. Okay, she makes up her own rules. Remember I said that earlier? She's eating dessert. What the hell? All right, so what we want to do, Evan gave me 9 points to remember. And when you think about those 9 points, if you just sit back and close your eyes and think, they're all really common sense things. They're all common sense things that all too often just go right over our head, and we conduct meetings, the great questions about minutes and reading and all of that. But when you boil it all down, a lot of it is just common sense things, right? I've been in this industry for a long time and done several different things, and there are several of you in this room that know me here, all right? I used to say, this is no disrespect to all the managers, I'm a licensed manager, the business itself is not, what do I always say? This is not rocket science. This lady I've known forever. This is not rocket science. It's common sense. It's following processes. It's following rules. There are certain things, statutes we have that govern us. We live in these boxes where we have to do things. But the rest of it, the operation, the day-to-day stuff, how we maintain our property, is not rocket science. So all too often what I found in the industry is we try to complicate it. We try to make it more complicated than it really is. Okay, so we just remember what we do today, keep things simple, right? Keep them simple. Let's use our common sense. Let's have good conversations. And you'll tend to move forward in a little bit of a better motion. All right? I want to turn it over for the really good part of our program. I only ask one thing, and I hope you guys don't mind this, and that is, as Evan said, we have a big group of people here. They have information to cover. They are attorneys. You do get a chance to get some free legal advice today. What I caution you on, and I hope these guys respect this, is I don't want to get into 57 questions about everybody's individual association. Because if we do that, we're going to be about 5 minutes on their program and 55 minutes on this is what happened last week at our board meeting. And all of you can relate to that. Do you agree with what I just said?
Yes.
Thank you. Now you can have dessert. All right, so if we stick under that premise, and if one of these gentlemen said, you ask a question and they say, hold on, or talk to me after, I'm prefacing that comment if they say it. It's not, don't take it the wrong way, but we want to talk to the audience, okay? Not 37 different associations. Cool? Perfect. They'll come in, they'll be serving, that's why they brought dessert. They'll be serving as these gentlemen are doing their programs, so just, give them some room, let them go around. If you need anything, keep the voice down. If you're going to talk to your partner next to you, do us all a favor, right? It's like the first thing I always say when I run the Chamber of Commerce meetings here for the city. The first thing I say is turn down your cell phone. Let's be respectful of everybody. Cool? That's all you guys. Thank you.
Thank you, sir. Thank you. All right, good afternoon, everyone. My name is Michael Kassower. Joel McTague and I are here from the law firm of Frank Weinberg and Black, and we're really excited to teach you the board certification course today that has been something that has been pushed pretty hard out of Tallahassee since its inception, about a decade ago?
2007, 2008.
2007, 2008. It's a great course, and I say it's a great course because, as I think is evidenced by the fact that we have so many repeat board members here, people that are not necessarily required to take the class, you get so much information out of this class that will be the types of issues that you inevitably confront a multitude of times. Not just in your first year on the board, not just in your first month on the board. You will get so much information today that you will see come to life in your operations as a community. So by taking the time to be here today, there is an alternative to the requirement. You could have just signed a piece of paper saying that I've read the governing documents, but you're actually going to get the information that will empower you to operate and candidly probably save a few bucks on legal fees along the way. Because instead of calling me to hear how do you handle a records request or how do we handle our notice for a board meeting, you may find that you get that information here today and you actually save yourself a bit of money as an association.
Is any of this going to be written down for us, or do we need to take extensive
It's in the
notes?
books.
It's in the book.
Okay.
So you'll see we have some bullet points that we'll use as an outline on our PowerPoint. What you have in front of you is almost like a textbook, I would describe it, where it's almost a full encyclopedia of information where we go into citing statutory language and really breaking things out. I would say that take that home with you and you can use it as a reference document is what I would encourage.
I would recommend using it for a cure for insomnia. That's the author of it. Is there any, reconfirm that there's nobody HOA, no co-ops here, right?
You just saved yourself an hour. So again, I think it really is a testament to the fact that this course really will prove valuable to you in your next coming year as you start, like most associations, in your new term this time of season. Now, Joel and I are with the law firm of Frank Weinberg and Black. We've been a fixture in the Tri-County area since the early to mid-1980s. Our firm has been dedicated to condo HOA representation, but not exclusively dedicated to condo HOA representation since that time. That's something that I think actually makes us stand out among condo HOA firms, and here's why. Anybody that's been on a board for a while understands condo HOA law is not just noticing board meetings and sending out collection letters. There are firms that tend to do a lot of that work and they do it well. But what you learn very quickly after you run your association for a while is that you are going to confront employment issues. You're going to confront construction litigation issues, contract issues. These are normal business operation things. And to actually say I'm going to go to my condo lawyer to get this kind of advice, it's not really a fair statement because there's so many different specialties that arise within condo law. And we're a firm of 26 attorneys. We represent businesses of various sizes, and about 35% of our firm's practice is dedicated to condo HOA work. So what you end up getting as a resource from our firm is a group of people who actually specialize in the subsets of areas that you will confront as part of your association's operations. As for Joel and I do take a moment to brag because we do want to let people know that we are competent to do this. Joel and I are two of the inaugural board certified attorneys, less than 100 who passed the test in its first year of operations. We are board certified in condominium and plan development law, which means through a series of peer review, aptitude testing, and a host of other demonstrative experience proven to the Florida bar, we have earned the designations as being experts and specialists in this area of practice. So it is something that we do feel like we really can speak to, and we have a lot of passion about, and as we've been doing it now, both of us, for 10, 20 years each. So we look forward to sharing some of our experience with you that we've taken in along the way. Now that being said, we're going to dive into our presentation, and we have just a general outline of what we're going to be talking about today. First and foremost, the lingo. You're going to learn very fast some hot button words that come up all the time in your association's operations. Material alterations, liens, foreclosures, things that you might be used to hearing but you don't know what they mean in the condo context. There will be a variety of things that are just your normal everyday jargon that you're going to have to become accustomed to dealing with in order to just speak the language. Elections. Most of you are here because you've survived that process. Recalls. Hopefully you don't have to survive that process. But we're going to go through the protocols because obviously, even if you're newly elected to the board and you've just been put on the board of directors in the last couple months, you will be one of the people responsible for making sure that the next election goes smoothly. Operations. This is the nuts and bolts of things. We'll talk about things like board meeting notices, meeting minutes, the things that I think there were some questions from the crowd. And we are happy to take some generic questions along the way, but we also just really do want to be sensitive to the fact that it's a relatively long course. We're cramming a lot of information into a couple hours, so we're happy to stick around afterward if you have any specific questions. Records maintenance. Official records requests are real. They have penalties if you do not comply, and if you do not have the records on file that you are supposed to maintain under the statute, you can get your association into a bit of a pickle. We're going to go through the records maintenance requirements as well as how to respond to official records requests under the statute. Budgets and reserves. This is I'll call this a two-pronged financial component of the course. Budgets, reserves, liens, and foreclosures. Obviously, as an association, you have a requirement to adopt an annual budget. You can have fully maintained straight line reserves. You can have pooled reserves. You can have partially funded reserves. You can waive reserves. In order to implement these different categories of reserves, there's different voting requirements to go to pooling method versus something less than fully funded reserves. Liens and foreclosures. This is your collection mechanism. This is the hammer of Thor that you have to collect your maintenance assessments. You are generally second in line only to the first mortgage bank, and so if people do not pay their maintenance, you have the ability to lien and foreclose on their units. You do get to recover your attorney's fees and costs, and you do get to recover other charges potentially as well. We'll go into the details in the process of that. ADR, Alternative Dispute Resolution. We're all condos here, so we're really just going to focus on the arbitration process. 718-1255, there can be mediation requirements as well.
But also as a little preview, the state may be getting away from the arbitration requirement this year, so we may want to spend a minute or two more on mediation.
And this is when I have to do my least favorite part of the presentation and put Joel on a pedestal slightly higher than myself. Joel is actually part of the real property section of the Florida Bar's advisory council to Tallahassee when it comes to rewriting the Condominium Act. Every year there are recommendations made to this legislative subcommittee that's responsible for the Condominium Act, and they do generally come from at least in part, the real property section of the Florida Bar. And Joel, I'm proud to say, with our firm, is one of the people that is a critical component of that advisory council. So he has a sneak preview into some of the things that are really actively underway, and before there's a potential amendment that's implemented, typically they take effect sometime in the summer. Joel gets to be able to give you the window into what might be coming down the pipe. So, alternative dispute resolution, that being said, we'll talk about that process. There is a out-of-court process for condominium disputes, at least most categories of them, other than collection of assessments, a couple of other categories of things. Q&A, again, we're happy to get into that at the end a little bit, both as a group, and we'll stick around individually. So please, any questions you have, we look forward to answering them. And with that, I'm going to hand the clicker over to the gentleman that's on that pedestal slightly higher than me, Joel McTague, and take it from there.
Thank you, Michael. So a couple of preliminaries going to the course. First, why is this course mandated? If you remember back in 2004, 2005, what happened to Florida? We got hit with 7 hurricanes. Florida legislature started getting complaints from unit owners because with the number of condominiums in the state of Florida that were catastrophically affected by those 7 hurricanes, unit owners were calling up complaining, my board doesn't know what to do. Frankly, the boards didn't know what to do because it was a virtually unprecedented situation. What was even worse was that a lot of the professionals that were helping the boards didn't know what to do because of the unprecedentedness of the situation. So what the Florida legislature did was they had a bunch of town hall meetings, 2007, 2008, and they were hearing these complaints that boards were not as educated as they should have been. Because, let's face it, most of you here are volunteers, some of you are conscripts, some of you are maybe getting paid under the table, but we won't discuss it. And then in 2008, the Florida legislature finally said, enough is enough, we're going to mandate a bunch of education courses for all the board members. Our firm was one of the first ones. We were actually the 16th group that was actually approved to teach this course, so this is one of the original courses. So what we're not going to cover today, Michael already gave you a good preview of what we're going to cover. Reasonable accommodations and emotional support animals. It's always a big topic. Unfortunately, the DBPR says we can't discuss that here. That's why in your package, in the folder, we have our new service animal advisory. Thelma has what it looks like in the back. The HUD has actually just issued the other week new guidance. So this is the latest and greatest on service animals right now.
And by latest and greatest, we still mean that it can basically do nothing.
We're not going to be able to cover material alteration. Again, DBPR says what we don't have time. Intellectual property issues. This actually is a big area, even though we may not even notice it. But we can't cover that in this course. Admiralty issues. How many people are on the water? Have your associations on the water? How many people have docks as part of their association? There's a whole other host of issues with regards to admiralty. What happens during the hurricane where a boat actually comes over, hits and damages your dock? And if you're on a navigable waterway, it may not be a state law claim at that point. It may go into federal court where there's a whole separate set of rules on admiralty issues. We're not going to cover a turnover. Anybody here have their associations recently turned over from a developer, or are most of you guys established? Because I know there's a few 10-year plus members. Okay. Easements, bulk telecommunication systems. Again, these are all things beyond the scope of the course. We won't cover discrimination claims either. Again, please try to hold your questions specifically to the end. One of the issues that we always have is this is a public forum. You may start asking questions that's specific about your association, and therefore you're breaching any sort of confidentiality at that point. You may not want to do that. I had that I think it was my third time teaching this course. I had my clients there. Pat Flynn, who was the head of compliance for the DBPR at one point, was my guest lecturer. And one of my clients cavalierly raised their hand and asked a question that I told him not to ask before the meeting. But he wanted to show off to the opposition group on his board, and Pat Flynn answered the question the way he should have. Again, this is a DBPR mandated course. Michael and I are not supposed to give any sort of things outside of what the DBPR tells us. We may not agree with what the DBPR says if you ask us outside this room. We're not supposed to make any remarks about what the DBPR says. But Michael and I are human, so we may occasionally say something. But the other thing to keep in mind, I have some of our clients go to other firms and they said, we learned this in this course, why are you telling us this? This is all the DBPR's interpretation of what the rules are. And if you remember last year, as citizens in the state of Florida, you voted for a bunch of constitutional amendments, one of which was to do away with something called administrative deference. That's Article 5, Section 21 of the Florida Constitution. Before, if you were sued by an administrative agency of the state of Florida, the administrative agency walked in and said, we are specialists in this area, the court has to give us deference to our interpretation. And courts had to give them deference. We did away with that last year. So what does that mean for the DBPR's interpretation of all this now? It means that it's only their view of it. If you went into court, you're on equal footing with them in terms of any of these issues if you disagree with them. Michael?
Okay. You'll see me get increasingly caffeinated and more entertaining as the presentation goes on.
Which reminds me, laughter is required, and we will hold your certificates if you do not laugh.
In a serious point about the lack of seriousness, I actually like to say this at the beginning usually. If you've been on a board for a while, you know how stressful things are going to get. When we joke around in this presentation, it's not because we don't take everything enormously seriously when it comes to what we do. It's just because a little bit of levity we find goes a long way. You're dealing with an intersection of political thought and people's typically their most valuable asset they own in their life, their home. So people get pretty heated, things get pretty intense, and sometimes we think a little bit of humor just allows people to grease the wheels and just get through the day. So that's the point of that. But now the warning, Cohen v. Grand and Figa v. Devon neighborhood. These are a couple of seminal cases in condominium and candidly all community association governance. Now what do they stand for? Anybody in the room familiar with something called Kaufman language?
Yes.
A little bit? Absolutely, and the changes, exactly. What Kaufman language is it goes back to a case, a Florida Supreme Court case back in I think the late 70s called Kaufman v. Scheer. And what happened in that case was there was a question with whether or not an amendment to Florida Statute 718 that concerned recreational leases, it's something that's really not as critical initially usually today, but if the amendments to 718 were something that should be applied to an association that existed before the amendments were implemented into Florida statutes. And what happened then, in the Kaufman v. Scheer case, and then the progeny, all the cases that came after it, was there was a determination that you do not automatically take every single amendment to the Condominium Act and apply it to every single condominium. Why? Because your condominium, while it is a 718 condominium, is governed by a contract. That contract is the Declaration of Condominium, along with the other governing documents as well. So you have a constitutional right to not have your contracts impaired, generally. Included amongst that right is your declaration. So for instance, the big case that really just illustrates it so well is Cohen v. Grand. Cohen v. Grand was a recent case, relatively in the last 10 years or so. And what happened there was an amendment to Florida Statute of 718 that said that if you are in a mixed-use condominium, commercial and residential, that the residential component of the membership must control the ability to elect a majority of the board of directors. The residential component must be allowed to elect a majority if it's mixed use. What happened in this situation was the original governance of the documents allowed the commercial owners to have a majority. Step in Florida legislature and say, no, that's not allowed. There was no Kaufman language in the declaration. And Kaufman language means we're governed by 718 as amended from time to time. They didn't have that magic as amended from time to time language. So what those commercial unit owners did was they elevated the case all the way up to the Florida Supremes. They love when we call them the Supremes. It really makes them feel like they're respected. And what they did was they elevated the case and they said, this is not fair. We had a contract that entitled us to control the majority of the board of directors. I never would have spent hundreds of thousands, millions of dollars on these commercial units if I thought these people in these residential units were going to be able to tell me how to operate my piece of property. And you know what? The Florida Supremes agreed. They upheld the precedent of Kaufman v. Scheer, and they said, Grand Condominium Association, you will be governed pursuant to the contract that you had in place. And the amendment does not apply because you did not have that magic Kaufman language as amended and from time to time. Learn it, love it, you'll see that it's critical. And one of the reasons why it's so critical is because and this is, blame Tallahassee, blame the people that wrote your documents, we just get to tell you what the laws are. It creates enormous confusion because you would think in this day and age that if I go onto the internet and I read Florida statutes, that I should be and I'm looking at the 2019 version of Florida statutes, we don't have 2020 yet, it comes in the summer. I'm looking at the most recent version, that should be the laws of the land. It's just not. Now there are situations where without Kaufman language things may apply. For instance, and we'll get into this a little bit more later on, there are some procedural mechanisms you may have in your documents, especially if you're a community that's more than 20 years or so old. You don't have anything in there about the election protocol of 60 days before you send the first notice, 40 days before you send the notice of intent of candidacy. You don't have anything in there about going to arbitration before you file a lawsuit in court, but these types of procedural things can be applied even without Kaufman language. There also can be sometimes health, safety, welfare things that can apply without Kaufman language. For instance, the general belief, although I don't think the courts have completely upheld this on appeal yet, is that the insurance portions of the Condominium Act are something that apply to all associations even without Kaufman language. And the reason for that is obviously insurance has a lot to do with health, safety, and welfare. Particularly after a hurricane, like Joel said, a lot of amendments came down the pipe because that was catastrophic to the condo HOA world. Okay, you've heard this now, I think 4 or 5 times, but common sense, and a lot of it is common sense, but then a lot of it is not. Unfortunately, this is where people get very frustrated with us as attorneys. There is a ton of bureaucracy, especially in the condominium construct. Again, we don't make the laws, we just get to tell you about them, along with the dissidents in your community who will also tell you about them if we don't give you a heads up in advance. So common sense, 100% should be a driving force in all business operations. Unfortunately, the Condominium Act and your corporate governance doesn't always follow that, and you have to put your common sense in a box. And that may drive you a little bit crazy, and this is a little bit of the levity you'll see from us. Unfortunately, the humor does get worse as the show goes on. But yeah, you really will, at times, lose your mind along the way in this process. I hate to be so blunt about it, but no good deed goes unpunished. You're volunteering your time, you're dealing with politics, you're dealing with people's money, and tempers flare, and people, there's an old study I remember reading it about 7 or 8 years ago, I forget which newspaper it was in. They actually hooked up electrodes to people's brains, and they had them talk about different things. They had them talk about business, they had them talk about their family, they had them talk about traumatic events. Guess what made their brains light up more with the emotional cortex of their brain?
Living in a condo.
Not all the politics. Politics just bring, and I think we all know that in this day and age, whichever side of the aisle you're on, politics really just, it brings out this visceral reaction in people, and so just, you really are at the intersection of politics and money. And then you throw in your pets every once in a while, and you're really All right, so terminology. DBPR, Division and Bureau. The DBPR is the Department of Business and Professional Regulation. It governs most professions in the state of Florida. I'm sure most of us have sat in our barber or hairstylist chair and stared at that DBPR certificate that they have hanging on the wall. They also certify a whole host of other professions and govern lots of areas of business operations, including condominium governance.
And boxing referees.
And boxing referees, and we do that too. But the Division of Condominiums, formerly the Division of Land Sales, is the subset of the DBPR that is responsible for condominium issues. And within that, there is the arbitration section, where you'll have those disputes under 718-1255, if you're familiar, the pre-suit arbitration before you can go to court. And then there's the Bureau of Compliance. I consider the Bureau of Compliance like the beat cops. You basically have these offices that are located more locally as opposed to in Tallahassee, where you can go and file complaints, and they have people that are like beat cops that will investigate the issue, and they can also issue civil penalties against you. So what's really interesting though, and interesting sometimes in a terrible way, is that they're not always unified. The Bureau of Compliance often disagrees with the arbitration section of the division, and that creates great confusion on top of the Kaufman language and all the other things that I'm explaining that really just cloud how things are supposed to work. The Ombudsman. The big time you'll really hear about this is the Ombudsman is responsible for election monitoring. Joel, any other things that we would talk about the Ombudsman in particular?
A lot of times I get calls from dissident unit owners claiming, oh, I spoke to the Ombudsman's office on whatever issue, and this is what they said. Well, the Ombudsman's office has 2 functions, really. One is to do election monitoring, as Michael mentioned. The other thing is basically to be the therapist to complaining unit owners. Otherwise, they have no power. If they turn around and say, oh, your association's not doing the records request properly, that has no effect on you whatsoever. It's only the compliance section or the arbitration section. And the other thing, sometimes, since the Ombudsman's office is a political appointed position, sometimes it's not necessarily a person who knows condo law who gets put into that position. at the past couple of, right now, we don't have anybody in that position. Governor DeSantis hasn't appointed anybody.
I called the hotline the other day, and this gentleman called me and said he was looking on Berkshire.
But he's not the ombudsman, though.
Okay.
As of last week, DeSantis still hasn't appointed the ombudsman yet. But since the office was created, there's only been one person who actually comes from the condo world who's actually been the ombudsman. No, it was Bruce Campbell.
And that's one of the other things to understand about the division. There's a political dynamic to it. Much like, the Attorney General currently may not share the same views as Eric Holder, the Attorney General under the prior administration. The new governor gets to appoint new directors of the division, ombudsman, so these things can change very rapidly. There's one issue, term limits, if anybody's familiar with the 8-year term limit that was recently amended. Very controversial. We've been at the epicenter of that, actually, with some pending cases. That's one that didn't about face when DeSantis came in and had his new people take over.
We still do not have.
So it's retroactive,
And there's layers of retroactivity, and we absolutely, we'll get into that.
Oh, I'm sorry.
No, absolutely. Right now, it's leaning retroactive, you are correct. Nothing is written in stone with the division, unfortunately. The 4 different categories of statutes, really, it's going to be 1 and 2 that you're going to care about. 617 and 718. 617 is the general not-for-profit statute. Given that you're all residential condominiums and you're confident that, and 99.9% are, you're all not-for-profit corporations fundamentally. From there you become a condominium, so you're governed by the Condominium Act, or Statute 718. I heard one comment out there about, no, we're a 711. That's actually the predecessor to 718, and so 711 was 718 before 718 was a thing, but they are both Florida's Condominium Act. There's also the Cooperative Act 719 and the HOA Act 720, but I think we have a nice clean room of condominiums, so we can steer clear of that. The court system. Trial courts, appellate courts. Important thing to remember, because at the end of the day, you will see lots of really interesting newspaper headlines about these amazing things that lawyers have done. Sometimes they truly are amazing, and sometimes they are things that you should actually consider when you're making decisions. But unless it comes from an appellate court, it is not binding precedent. Don't be surprised if a lawyer goes out and starts bragging about an incredible result, only to have it overturned on appeal a couple months, or more realistically about a year or so later, because appeals don't go that fast. So trial courts are important in that they can tell you where the wind may be blowing, but appellate courts set binding precedents. The Division of Condominiums does not, and the trial courts do not. All right, trivia time. Can I start off with the first round of trivia?
Yeah, you can do the first trivia.
All right. Joel is the brainchild for most of the trivia questions, so he shares with me sometimes. Anybody have a guess of how many people live in condominiums in the state of Florida?
8 million.
Millions? What are we?
16 million.
Over or under 1 million?
I'm missing my.
Over, under, over? Okay. We'll go with over, and the answer is 1,524,000 declared residential units in 23,000 associations. We are talking about that you are truly at planned communities. Florida, they're one and the same almost at this point. It's really, there are very few non-planned communities. How many people are in HOAs? Over 2 million parcels, close to 3 million parcels. Co-ops, more common in New York than they are down here. Co-ops, we have 84,000 units and 788 associations. The Community Association Institute has told us that in 2016, there were 47,900 combined projects representing close to 10 million residents. It's really an astonishing figure. All right, now we're going to get into board eligibility. Yes, ma'am.
HOAs and condominiums.
HOAs? There are, look at the number of projects. There are 14,474 projects.
Right, and there may be more individual parcels in the HOAs.
All right.
Maybe they don't have more co-ops.
And now we're going to move on a little bit past the trivia time. Trust me, you will get more of this as it gets better and better, I promise. Condo eligibility, I'm gonna hand things over to Joel. We're gonna talk about some of the things that can render candidates for the board or current members from the board ineligible for seats on the board of directors.
Michael? First thing to get you knocked off the board is if you have been convicted of a felony. Anybody here who's have been convicted of a felony, don't raise your hand. Because well, it's not even funny, I just had one issue come up last night in an election where one of the candidates, it turns out, was convicted of a felony. In his previous community, he pulled out a shotgun, threatened to shoot all his neighbors. And he would claim that he didn't do it, even though that when the police got there, they found the shotgun, the ammunition, and all that. And he ran for a board, but nobody found out about the fact that he was a felon. Never had his civil rights restored, so therefore, he's going to be banned from serving on the board. You have to have your civil rights restored for 5 years. Now, remember before when I mentioned all the amendments we passed to the Constitution last year? One of them was that if you were a felon, you would have your voting rights restored. This does not get affected because the Constitution only applies to voting rights, not to all your other civil liberties. So one of the things that is somewhat humorous is that if you're convicted of a felony, you can't own a gun. There is an actual DBPR case where a person went in and got all his civil rights restored except for the right to own a gun.
Thank you.
And there, you know, if there's one person in all your communities probably that is rather annoying and checks everything. And if you're that person, you're a good person, but to the rest of the board, it sometimes gets hard to deal with. Well, that one person, annoying person in that community, found out about this one guy's criminal activity in the past and went to the DBPR, and the guy said, all my civil rights are restored, I just can't own a gun. And the DBPR said, no, the right to own a gun is so enshrined in your board membership that you have to have your right to own a gun. Which then brings into the question before when we were talking about best board practices, about fighting being on the board, why do you need us to bring a gun to a board meeting? I'll get into that as soon as I'm finished. Board member terms expire at the annual meeting. If you have more candidates than not, you have an election. If you don't have enough candidates, everybody continues to serve. If you have a condo owner, if you have more than 10 units, you cannot serve together unless there's fewer people serving on the board. If a person is suspended, you cannot serve on the board. Now, I've asked the division multiple times over the course of the year since that came in 2008, what's going to take to remove a board member? And they said, we have no idea because we haven't crossed that bridge yet. So we're 12 years into it. If a unit owner owes any money, they're not allowed to be on the board. Now, that doesn't necessarily mean that they are delinquent in fair assessments. It could be that there's a fine. It could be as simple as a reimbursement. Had a case a few years ago where a unit owner she was one of those annoying unit owners that needed the board, and there was a construction project that going on in the association. He decided to get even and called up the porta potty company and had the porta potty moved to in front of the president's unit. And he impersonated the president in doing that. And we contacted the porta potty company, they came back and moved it. It cost $20 to move a porta potty across one building, if anybody was really wondering about the numbers. But we sent a letter saying, oh, by the way, you owe us $20 in reimbursement. DBPR said that was enough to keep him off the board. No formal assessment, no fine, just a mere request for reimbursement of money. So, yes,
Is there a time frame? What I heard was it's over 90 days,
that's for suspension of voting rights or abandoning office, which I'll get to soon.
but not as far as running.
Not as far as running. On the 40th day, and Michael will get to that, you have to do that. Now, these are the only reasons to keep somebody off the board. Now, I want to read a set of bylaws that I just recently found in one association, which shall remain nameless. But I will give you a hint on it. I am on my own association board. I'm the secretary of my board, so I'm just making from my bylaws. Intoxication and use of alcohol or non-prescription drugs or medication. If a member of the board of directors is observed consuming alcoholic beverages or non-prescription drugs or medications before or during a meeting, or is intoxicated or under the influence of a non-prescription drug or medication while participating at a meeting, the board of directors shall have a right by majority vote of the board of directors to remove that member of the board of directors from. Any removal shall disqualify such person from becoming a member of the board of directors for a period of 12 months after the date of such removal. Now, I have no idea what prompted this, because I've never heard of board members doing cocaine or other drugs at a board meeting. But I think this is probably illegal, given the fact that this is a pretty exhaustive list. Now, the portion about the 90 days. If you are elected to the board and you are delinquent by more than 90 days, at some point during your board membership, you are automatically removed. The board does not take any action to remove you. You are automatically off. And if you come back and say, here's my money, you're still off. That's only for conduct. Right. So, Michael, do you want to start?
All right, it's election night in America. Everyone's probably emerging from this right now in this room, or I would venture to guess, probably a couple that still have elections running through April, but this is really in the middle of election season for us right now. It's the late winter, early spring when most elections seem to happen. And here's the protocol, if everyone doesn't remember. 60 days in advance, at least 60 days in advance, you have to mail out the first notice of the annual meeting at which the election will take place. In that first notice, you will be affixing various other deadlines. The next deadline that will come is at the 40-day mark. Sometime 40 days or sooner, anybody that wants to run for the board must submit a notice of candidacy. That date has a lot of critical significance. That is the date that you determine eligibility for other purposes, i.e., if you are delinquent in any monetary obligation to the association, including the $20 porta potty fee Joe was just talking about, if you are delinquent on that date, you are not eligible. What if I walk in with a check for the $20 on the 39th day? Sorry, you are still not allowed on the ballot. That is the magic day. No board meeting requirement to vote to remove somebody from the ballot. It is how things must be done. If you include somebody on the ballot that was not current on a monetary obligation and someone raises a challenge, you will be forced to conduct a new election on the association's dime. 35 days. That is when everybody must submit their candidate information sheet or their resume. It's an 8.5 by 11 sheet of paper. They can pretty much write whatever they want. We've had people submit cartoon drawings of what they think the ex-president should do to themselves. It gets graphic, it gets ugly, and you have to publish it. The association is not liable for the things that go into that document. Except, and Joel is the First Amendment lawyer, and he will say that there are some confines to that probably now. But it is something that there is general need. Joel, do you want to caveat it?
Yeah, but it's the next slide anyway.
Okay, there you go. So we'll get to, yes, sir.
This first 60 days notice, I'm going to specifics, but I'm from out of country, okay? They hold back the letter because they know it'll take 8 weeks to get out of country, and they hold it back. And then you don't have enough time to mail it back to say you want to run. How is this affected by the 60-day notice? Once they put it in the mail, it's 60 days, doesn't matter where it's going to, or?
That is what the statute says, and we have communities that are investor heavy, a lot of foreign owners, and we have that situation arise a lot, especially because more so than the first notice, although I can appreciate why you have basically a 20-day window for the first notice to get your notice of candidacy in. The one that gets really controversial is the second notice, because you might theoretically send that out as close as 14 days before the election. Somebody may not even receive their ballot until after that 14 days, potentially, if you're sending it somewhere particularly in the other hemisphere, or one of the other hemispheres, depending if you go north, south, east, west. So the statute has no protection for it. All I can say is there is an option now to do electronic notice if people opt into these things and electronic voting. that's a way around it if as an association you want to try to help those members out and participate. Electronic notice and electronic voting. Yes, ma'am.
Does the resume have to be about yourself, or can you put in things about the board and other people?
The latter. You can put in things about other people, criticizing the other board members.
Anything you want in it.
You can put almost anything you can think of in there. If you don't want to even discuss the condos, you just want to do a poem, you can put in a poem if you wanted to.
And now Joel's project near and dear to his heart, federal mail laws.
Okay, as Michael mentioned, one of the things that is in Florida statutes is that under Florida law, associations are immune for whatever goes into the candidate statements. And there was Michael and I are a member of a listserv for condo attorneys, and there was a conversation a couple of weeks ago about whether that's really true or not. And they were discussing the possibility of an association being liable for defamation actions, and I didn't necessarily buy into the one attorney's argument that I heard on it, but it did get me thinking that you're using the federal mails for things, and there's a whole bunch of federal mail laws out there of things you cannot put in the federal mail. So my nightmare scenario is what happens if a unit owner decides to do that just to annoy the association and get the association in trouble. One of the big common sense things is, as Michael mentioned, the picture about what the one person thinks that the board president should go do to themselves. What happens if it happens to be a board president? Another one. What if the person says, let's get rid of all the clowns running the association? How many people think that may be legally actionable? 18 USC 43 says you cannot use the US mail to threaten a clown. It's one of the more humorous examples, but it's out there, and I think most of us could see a candidate possibly making a statement like that in his statements. Now, what happens if somebody says, and especially if you have a nautical-themed condominium, I'm Pirate Jimmy, and I think we should seize this ship.
Is that pleasure? Good.
Anybody think that may be problematical? Maybe. If you have another pirate in the association. But the definition of piracy is very broad, so it's very possible you could have somebody in the association. Now, what if somebody says, I'm a weatherman and the unit owners are creating a storm and we're going to knock over the previous board? That's actually legally actionable because it is a violation of federal law to impersonate a weatherman and give an inaccurate weather forecast. Not that these things have actually gone through yet, or that Michael and I have seen any examples, but these are the nightmare hypotheticals that we deal with. And occasionally it keeps us up at night, and when we start coming up with absurd examples, they tend to come true eventually. So I'm just waiting for these cases to come out.
There was a unit owner that wrote us a letter calling us clowns, but I don't know if that's what
But I think that was there's a truth in defense.
Yeah, there you go.
But he didn't threaten us.
Fair.
Yes. So, going back to the condominium ombudsman, one of their functions is to appoint election monitors. 15% of the unit owners have to petition for the election monitor. The association is responsible for the cost of the appointing of an association for an election monitor. Most of them do a good job at running the elections and takes the heat off of the association. Because how many times in a contentious association you're hearing stuff like, oh, you fixed the election on the board. At least here you have an independent government agency running the election for you, for the most part. The one weird thing about this, though, is at the end of the day, if the Ombudsman's office makes a determination on something, you as an association are liable for that determination if it turns out to be wrong. If the Bureau of Compliance or the arbitration section later turns around and says the Ombudsman's office is wrong. Again, when Michael mentioned that they don't agree with each other, this is another area where they don't intend to agree with each other. When you go to Tallahassee to Blair Street, their office, and you turn to the left, You go into the arbitration section, you turn to the right, you go into the compliance section, and when you go downstairs to the basement, you come to the ombudsman's office. So that's how they view the ombudsman, and one of the telling things is there's a big conference in October for condo attorneys where the DBPR comes. Often they don't even let the ombudsman up on stage with the rest of the DBPR. So, Michael, do you want to do quorum?
I'll take over your service.
Okay, for condominium associations, you need 50% plus one. One of the big misconceptions for associations is you do not have a legal obligation to get quorum for your annual meetings. And one of my two big nuggets of information that I hope everybody walks away with, if you are going to have an annual meeting, don't go for quorum. Don't spend any time collecting proxies. Don't even bother sending out proxies. Nothing good comes from getting proxies unless there's a specific exemption. I would say 99.99% of the time though, it's a complete waste of time and effort and paper. So get away from it. I know unit owners are going to start accusing you guys of everything. The common retort that I gave is what business was going to occur at the association anyway that we needed a quorum for. What's more important at an annual meeting is the return of ballot. You have to have 20% return of all the ballots to actually have an election. Anybody here have any other business that goes on at an annual meeting? Exactly. So why do you need to invest any time or effort in going out getting proxies if there's no need for them at that meeting? Use that for when you're going to have amendments to your declaration or other things. That's, have it at a separate meeting.
So for updating the condominium documents, you would use a proxy, you would need a proxy.
Or a written consent depending on your size. There's strategy in choosing which of the methods to use, but I would always have it at a separate meeting. I would not have it at the annual meeting.
All right.
We have a budget, budget approval.
Budget meetings are considered separate meetings under Florida law.
So if you end the meeting and then have a meeting after that, like close it and then have another one, that's okay?
Yes.
I know that the membership decides whether directors are paid, compensated. Is that okay to do it at an annual meeting? In other words, include with the ballot?
I would always do it at a separate meeting because it's just we would have to have a separate conversation about the politics of your association or not. My knee-jerk reaction, as a general rule, is always have everything else at separate meetings. Compartmentalize, that way you don't have cross-contamination, you don't have a dissident unit owner group that comes to the meeting, takes it over, and starts screwing everything up.
All right, moving on to term limits now. This is a hot button issue in condo land. 2017, the Florida legislature in their infinite wisdom and in reaction to a grand jury report from Miami-Dade County about corruption on condominium boards, implemented a term limit provision to Florida Statute 718-112. It was tweaked in 2018. The way it currently reads, and I'm paraphrasing, is that you cannot serve more than 8 consecutive years on a board of directors unless A, you get at least 2/3 of the vote cast in that election, or B, there is not enough other people willing to run for the board. So why is this so controversial? It seems pretty straightforward. We go back to Kaufman language. So if you back up to this time last year, actually about a year and 4 or 5 months ago, there was a case that came down called Apollo. It actually wasn't a case, it was a declaratory statement. And what basically happened was the Apollo condominium went to the division and said, we have an election coming up and we have somebody running for the board. They've been on the board for about 10 years or so, let's say. We do not have Kaufman language that says we bring in amendments to the Condominium Act. But is this a procedural or a police power or something else that should be applied to our condominium? Again, we don't have Kaufman language. And what the division came back and said is, we don't care if you had Kaufman language. They didn't explain why, whether it was procedural or police powers, but they said, we are going to apply this retroactively. And we are going to make you, as somebody that has been on the board for more than 8 years, go out and get 2/3 of the vote cast. And right around about a month after that decision was issued, I mentioned we were at the epicenter of this. We were hired by a pretty well-known condominium in Palm Beach County. And that condominium had a serious issue that arose in connection with this whole dispute. And they were looking to Apollo, and they conducted their election, and they said to two of the candidates, actually, the former president and vice president, that they could not be seated on the board, even though they got a majority of the votes cast in that election. They were not allowed to be seated because they did not get 2/3 of the votes cast in that election. And for Apollo, that association thought that they should not seat those 2 directors. Fast forward, the president and vice president come after the association. Seat us on the board. The people spoke. They want us on the board, and we do not have Kaufman language. The Arbitration Act, first they filed in court, which was a mistake because everything is supposed to go to the Division of Condominiums for arbitration when it comes to an election dispute. So eventually we got kicked out of court, we go to arbitration. And in the midst of the arbitration action, lo and behold, another decision comes down called Glance. It basically, again, we mentioned that declaratory statement wing and arbitration wing don't always agree. There's also a change in administration from late 18, when you had Governor Rick Scott, to Governor DeSantis, new people, who knows what the exact cause is, but they issue an opposite opinion. Basically in direct opposite to Apollo. They say that it is something that requires Kaufman language in order to be retroactively applied. So you are correct, that is the way that the wind is blowing on this issue, is that unless you have Kaufman language, you will not be bound by this amendment. Now there's degrees of retroactive questions that have still not been answered. For instance, let's say you do have Kaufman language. Does the 8 years start to run in 2017, 2018 when the amendment took effect? Or am I going to be penalized because I sat on the board before this amendment even existed? Did you start counting the 8 years in 2009? Or do you start counting it when the new rule comes into place? I'll let you know when I find out. In the meantime, we have no appellate decisions on this. The division can change their mind at any time. The trial courts can change their minds at any time. Unfortunately, even though this change took place, we did win for our client, because one fun thing you should also learn when it comes to condominium elections, you have to make sure that you file your arbitration action within 60 days of the election. Because that person in this somewhat infamous condominium in Palm Beach County filed in court first, mistakenly had their case dismissed, and then filed an arbitration after the 60 days, even though the law changed in their favor, their opportunity to challenge the election expired and our board report is in place. So remember that technical requirement if the time comes.
But one thing that I'll give as where the winds are going, additionally, the Florida legislature, and one of the current condo bills that looks like it probably will pass, is that they are going to specify in the bill that it's only going to be for years after July 1st, 2018, that they're going to count toward the 8 years. So it really won't come into effect until 2026.
All right. We'll move on to some more election issues and voting issues. I'm going to put them all on the board. How many times have people had issues arise with whether or not someone voting on behalf of a corporation without a voting certificate can vote? Controversial issue. You also have jointly owned units, husband and wife. Sometimes the documents even say specifically that the husband and wife or any jointly owned unit they both must sign. The Division of Condominiums has taken a pretty liberal approach to these issues, and by liberal I mean this. If you have strictly enforced these rules in the past, then you can strictly enforce them in the future. But if you don't strictly enforce them, the division generally believes that you should err on the side of enfranchisement, not disenfranchisement. So what we typically do is if a voting certificate has not been strictly enforced in the past, if we don't have a nice binder walking into the election so we know that we have these voting certificates on file for our corporately owned units, we tend to err on the side of allowing votes so long as we can otherwise corroborate that the person is authorized to vote on behalf of that entity. How do we do that? Everyone familiar with SunViz, the Florida Secretary of State's website, we can go online and see the officers and directors of corporations, just like everyone can see that you are directors of your association. Every year. Every year is the requirement, otherwise you'll be administratively dissolved.
So you could be a year at a time.
You could be a year behind, and if we can't verify it otherwise, typically I would say then you have to throw it out. But if you have some way of connecting the two, then we like to err on the side of inclusion. But ultimately, you decide as an election committee what to do.
If they're not registered with Sunbiz for 2 or 3 years, they automatically dissolve, are they notified, or somebody has to find it?
You have to file an annual report every year. You get a notice in your email box these days, and if you don't pay your fee for and everything like that, you do get administratively dissolved online. It actually doesn't terminate the entire corporation as far as operations, but that could be a whole other legal seminar. But that's the resource we can go to vouch for things if we don't have the voting certificate. Does that answer your question?
What if it says invalid on there? Since 2015, it's been invalid. What does that mean?
What would you do invalid? I mean, this is
Technically under 607 and 617, as well as the Limited Liability Act, just the fact that it has been inactive and administratively dissolved doesn't mean that it has been actually dissolved. That's two different things. That just merely means when it's been administratively dissolved, that they do not have the right to be a plaintiff in a lawsuit in the state of Florida. That's the only thing it really means, and it also means that they've been very lazy and not filing what they're supposed to do under the law.
all right. Trust is the other one that we see come up in voting situations a lot. If you're a trustee, then you are allowed to vote on behalf of the unit. You don't need a certificate of any kind in that situation. Typically, the deed itself will actually list the trustee. Obviously, that can change with the passage of time. So if they can otherwise evidence it, meaning that if there's a new trustee and they produce some sort of document of authority on behalf of the trust, that can be sufficient as well. Condo crimes. We talked about that Miami-Dade County grand jury report that came down a couple of years ago. There was a whole host of amendments that came down the pipe. Be warned, although there is really not a whole lot of precedent of enforcement, there are criminal acts that lie within the Condominium Act these days. If you commit one of these crimes, you can be criminally prosecuted for these violations. Typically, they do involve some sort of self-dealing. You're taking things, receiving improper personal benefit, election tampering, forgery of ballot envelopes, theft, embezzlement. And then, oddly enough, this one is the one that really just scares the bejesus out of me if anybody ever took it too seriously. Failure to provide official records. I think what they're really going to be concerned about in the real world with this type of situation is if something fishy is going on and official records disappear in that context. I think that's almost going to be like the way that you catch the mob guys on racketeering. If you're suspicious and you see all the smoke but you can't find the fire because the records just disappeared, then that's the catch-all I think that they can go after people for. Trivia time. This one's actually pretty good. You want me to do it again, Joel? You got it. Okay, thank you. All right. First condominium in history. Any guesses? Any guesses? Roman. Okay, that's a good guess. Any other guesses?
In the caves.
The caves. Interesting. Vertical. That could be vertical if you have a nice cave structure. 434 BC, Babylonia.
Wow.
And has everyone finished eating yet? Okay, I'm nervous for this one every single time, and it's actually true. And Joel, now I wish I let you do this one. I forgot about this one. How did Romans pay for their condo assessments? You're in the right category, unfortunately. It was in ancient times a substitute for bleach. What was it? This gentleman got it. Urine. Urine. I bet you probably have some unit owners that might try to pay you with this at some point in time too, so be careful when you open the drop box.
We actually had an association down here in Dade County where it was an older association. They had one of those nighttime drop box, the old-fashioned ones, and a unit owner figured this out and was mad at the association, so they paid their annual assessment as well as the special assessments. If you know what I mean.
All right. Any Seinfeld fans in the room? Anybody? Okay, good. We can get along with it. There was a famous episode, Morty Seinfeld, Del Boca Vista.
Yes.
All right. The recall is real. Joel is the expert. I'm going to hand things off to him for a moment right now, but we actually have a fun connection to this community. Joel can talk to you.
Yes. The community that this is based off of Well, first, those episodes of Seinfeld were written by Larry David, you know, Curb Your Enthusiasm. His father, Morty David, was president of a condo in Sunrise here in Florida. We represent several of the sister communities, and all the stories from those episodes occurred in this group of sister communities. The president whose son gave him the car, and they accused him of being on the tape because the son wasn't that successful enough to afford the Cadillac that they gave his father. That he recently just passed away at the ripe old age of 101 after 27 years as being president of that association. So, anyway, recalls. Hopefully you will never have to go through this, but just in case, the DBPR tells us we have to let you know what to do because this is one of those areas that's easy to get tripped up on. And we're going to be doing the current version of the law, and I'll explain a bit about the history in a second. There's two ways to do it. Either the unit owners can call a meeting of all the unit owners, or they can do it by running a recall petition. 99% of the time, the unit owners screw up on this portion, so that makes you feel a little bit better when somebody runs a recall. Now, a meeting requires 50% of the unit owners to show up on. And again, remember when I said not to hand out proxies? That's one of the reasons. Or the written recall is where they go around and they get 50% of the unit owners to sign a petition saying to remove you from the ballot, or to remove you from your seat. Now, one of the things, in the few times that we do have recalls, the board always says, oh, they're committing fraud. They're not telling them all the truth. So stop them on that grounds. That's not grounds. There's a famous case where somebody walked around the building and got signatures, and on it, the petition, there was a sticker on the top that said, we want to ban dihydrogen oxide from the building. Anybody know what dihydrogen oxide is? Does it sound bad? Water. It sounds bad. And they listed all the things that are bad about water, how it's been one of the biggest components of acid rain. Most people vomit from a lot of it. It causes drowning, etc., etc. And people signed it. Over 50% of the condos signed it. And they submitted it. And they pulled off a sticker and it's like, oh, they recalled the entire board. Wow. And the board challenged it, and the DBPR said, no, people should be smart enough not to sign things unless they know what they're signing in particular. So when you get that recall petition in, you have to have a meeting within 5 business days to affirm or reject the ballots. And if you affirm the recall, you're off. You have to turn over all the materials, or that board member has to turn over all the materials. If you reject the recall, on both sides, the person who is affected by the recall, whether it's the person who's proffering the recall and it doesn't get accepted by the board, or the board member who just got recalled, they can challenge the election or challenge the recall within 10 days with the DBPR. Now, the old rule used to be that when you got the service, if the board rejected a recall, the board had to sue all the owners for rejecting the recall. And it became an administrative nightmare on doing stuff like that because given the short period of time, to prepare a whole entire administrative complaint, and part of the issue is you have to document the reason why you rejected every single ballot. So imagine if you have a very large community and you have hundreds and hundreds of ballots, and you have to document the reasons for rejection for every single one. It gets very complicated in a very short period of time. Trust me, I've been there before, going through over 800 ballots and writing up the reasons for every single one, sufficient enough to get it to the DBPR. Yes, sir?
Yeah. How do you deal with a situation where I'm out of the country and I didn't get the notice at all, never mind 5 days? They didn't let me know I was recalled.
We will get into that a little bit in the official records section. Yes, sir?
So in Seinfeld, they impeached you.
Yes.
Is that really the right legal term?
The right legal term is a recall. Yes. Again, you have a bunch of New Yorkers writing.
Right.
So, but same concept. So here, when you do get recalled, make sure you have a shredder nearby so you can shred everything that identifies all the illegal things. I did not say that, I did not say that. So operations, you want to do? Sure.
All right. Operations.
Excuse me, wait, what about if you challenge the whole,
The whole board.
If you challenge the entire board, you have to make sure you name replacement candidates. If you challenge a majority of the board, you have to have replacement candidates. If you're not challenging the majority of the board, you cannot add replacement candidates. If you add replacement candidates, it could affect the recall process at that time, if you're doing a few around a majority.
All right, moving on to operations. We're on our next bullet point in that big outline at the beginning. This is the nuts and bolts of operations. I think that you're really going to obviously deal with as operations. Here's the categories we're going to go into. I'm going to lay it out for you first. Governing documents. That's your declaration, your bylaws, your articles, and your rules and regulations. The declaration is your most important document, I would say, for 90+% of the things you'll confront, other than process with running meetings, in which case you'll probably look to your bylaws a little bit. The board structure, that will often be set forth in the articles and the bylaws, some combination thereof. It'll say the number of board members, it'll say the officers, it'll say who's eligible for those things. Fun fact, unless your documents specifically say that only owners are eligible to run for the board, anybody can run for the board. This is something where, as ironic as it might be, to vote in an association, that's something that goes with an owner. But to serve on the board, not necessarily. And you just have to look to your documents. Sometimes it does make it clear that it's exclusive to owners in the community. Often it does not as well. Meetings, it's going to be everything in your declaration and your bylaws. Again, in all likelihood, will lay out the meeting notice requirements, the bylaws in particular. It's also statutorily driven. You'll have different categories of meetings. You'll have your ordinary board meetings, your reserve and budget meetings. You will have your annual election. There's different processes, special assessments, material alteration votes. There's all different kinds of meetings, and they have all different types of notice requirements and other things, mailing requirements that go along with it. RRM, repair, replace, maintain. These are the various duties of owners and associations, and your governing documents, typically your declaration in particular, will delineate who is responsible for what. Generally speaking, and this is a general rule of thumb, don't assume it to be true if an issue arises, is that an owner is responsible for MMR or RRM for their box, the box of the condominium unit, but the inside of it. So basically, when I put my hand on the wall of my condominium unit, I'm touching what you call the parametrical boundary to the unit. I am responsible for the finish on the wall, the wallpaper, the paint, the tile floor, the marble floor, whatever you might have, the finishes of the unit. I'm responsible also for the kitchen cabinets, the things inside the unit. The drywall, on the other hand, is typically the association's responsibility. So what you often see, God forbid there's a catastrophic hurricane that tears through and levels a building. What happens afterward is you're going to come back into your unit after insurance has done its thing and everything's been built back up, and the association's insurance responsibility combined with their maintenance responsibilities will result in you walking into a unit with maybe a primer coat of paint on the drywall. You'll have no kitchen cabinets because those things are the unit owner's responsibilities. So there's a delineation in your declaration as who is responsible for what. The biggest issue that tends to arise in this situation, especially with associations that are 15, 20, 25, 30 years old, is plumbing. The pipes, I heard it right there. There's oftentimes a situation where people assume, rightly and wrongly, it depends on the declaration, that as soon as you break off that vertical pipe and the line only services one unit, you automatically can be sure that that means that the owner is responsible for that pipe. But sometimes that pipe is located.
Explain that again.
For instance, okay, so you have, what you often see is you'll have if you're in a vertical condominium, obviously, you'll have a water line that runs up and down the stack of units. And then at some point it breaks off, and the line will run into an individual unit, and it breaks off again, and runs into an individual unit. And there's a belief that's often true, but not always, depending on your documents, that as soon as it services only one unit, that plumbing line, that it is automatically the owner's responsibility. It's not always the case though. Sometimes that plumbing line is encased in concrete. And as a unit owner, they'll practically, aside from the legal language in the declaration, question, how can I be responsible for making sure a pipe is okay that's encased in the concrete when you are responsible as the association for that concrete? So this is a major issue. The mystery of a water leak and who is responsible for it is, it's something that will, I would almost, and I'll get your question. Everybody in this room in a condominium is at least 10 years old? How many people have had a water leak issue since they've been on the board? And it's not going to be one. As the infrastructure ages, it's going to happen more and more and more. So just be forewarned, understand who's responsible for what, try to be out in front on it, but also understand it's a quagmire and your documents don't always clearly contemplate every inch of the plumbing or electrical or what have you that might arise.
And who makes the decision?
The decision ultimately gets made partially by me as the lawyer to try to review the documents and decide. Ultimately though, the insurance company. Because what I would recommend to most of my clients is you submit it to insurance if it's any substantial claim, and then the insurance company will fight through a process called subrogation to try to go after a unit owner and say it's their responsibility. That's what you have insurance for. Having the hourly clock tick on me is beneficial to a point, but then at some point, if it's a big enough dollar figure in dispute, you have insurance.
If it's under $1,000, it's probably worked out between the owners.
Often.
You're not responsible either. If you're
We'll get to insurance a little more, but to some degree, the way we read the insurance laws, it's like a no-fault situation a little bit, kind of like when you get into a car accident.
So how true?
Yes, sir. And you had a question first, sir.
Main feed in the water. Of course, there has to be a shuttle for inside the condo. Our condo says they're not responsible for the valve shutting off the main feed, which is part of the concrete feed. Is that possible?
I have to look to your documents. Yeah, it's all document specific, all these things. I have associations that say that it's when it breaks off the main line. I have associations that say that it's up to 1 inch outside of the concrete. It really varies from association to association.
But that main shut-off shuts off the main feed. So why would an individual on the inside be responsible?
Because your documents say it.
If it was always come upstairs, coming down, the person downstairs has to take full responsibility.
We will cover that.
All right. Yes, we have lots of questions. Okay. We'll go this way. Windows that varies from association to association too. I've actually had major litigation about this because if you've gone for impact glass in your community, that's the big one. Whenever people go for impact glass, there's a really interesting provision of 718 that came down after the hurricanes that allows you to escape material alteration voting requirements. Typically, material alterations require 2/3 or 3/4 of the members to approve. So for instance, before this amendment that I'm about to tell you about, if you wanted to go from regular glass to impact glass, then you had to go for a vote of the owners and get that 2/3 or 3/4 threshold. But when they amended Florida Statute 718 in response to these hurricanes, this was really, I think, a health, safety, welfare concern, wanting people to have hurricane protection. It was decided that if the association is responsible for the windows, driven again by the documents, you have to look to the documents, different condos are different. So if the association is responsible for the windows, then the board of directors has the power to vote to implement that mandatory impact glass across the property. If it is a unit owner responsibility though, you still have a lower threshold. You don't have to go to 2/3 or 3/4, but you need a majority of the voting interest of the association in order to mandate the impact glass. But to answer your question again directly, this is document driven. I have condos that say that it's the association's responsibility. I have condos that say it's the unit owner's responsibility. And then in the case where I had 16 unit owners band together and hire a very quality law firm to litigate this serious issue that involved a $20,000 per unit special assessment, I have documents that are silent on it. And then we have to go to other areas to try to clarify the situation. And by the way, in that case, what ended up being the silver bullet, don't be afraid to look at those exhibits that you tend to ignore at the back of your declaration. There's legends at the bottom of those things that say, this is the common element. After litigating the case for quite a while and having a faded set of governing documents, we found a little legend that had a perforated line that said common element. And that perforated line was exactly where the windows were located.
What if you can't find the documents? Going way back when?
You can't find your declaration?
No, nobody has them.
I'd consider hiring the law firm of Frank Weinberg and Black. It should be recorded in public records. That's what, there should be a way to find it. I don't know how old you're talking, but there should be a way to find it.
72?
Sometimes they're not electronically available. When you get pre-1970, sometimes you have to go and actually get the physical documents because they're not online. Okay. Remember I talked about the caffeination? I'm going to start to go faster because I want to get you guys out of here at 2 o'clock. Amendments. There's amendment voting requirements. We'll get into that process as well. This is just the outline here. We've gone into depth a little bit. Contracts, there's bidding requirements. We'll get into that as well. I'm going to get to the actual slides now instead of talking about things at length. Trivia time. We'll go through this one again quickly. Now we're talking about the first condominium in a U.S. Commonwealth. Anybody ever guess what Commonwealth that was? Commonwealth is the giveaway.
Pennsylvania.
Pennsylvania.
I know, never mind.
In the United States.
Never mind.
In the United States.
Pennsylvania.
Go west. Go west. Go a little bit east. Greystone Manor in Salt Lake City, Utah. If you didn't think that Salt Lake City, Utah was exciting, now you know it is. All right, and this is a picture of Greystone Manor. And if you're a really strong Republican in this room, you may disagree with statement. What prominent Republican's relative is responsible for this? People are getting the answer a lot quicker now that I give that clue. It is a relative of Mitt Romney. It was Keith Romney who drafted this set of governing documents.
Second cousin once removed.
Who did he say was responsible?
A Romney family.
Romney, right?
Romney family.
All right, we're clicking through again fast, and remember, all of the more detailed explanations are in your documents here, the reference book that you have at your disposal. But these are the different levels we talked about, the deck, the articles, the bylaws, the rules and regs. What makes the rules and regs really interesting is they're often controlled by a vote of the board of directors. What you should be careful to look for in promulgating rules and regulations is the scope of your authority. Sometimes the rulemaking authority extends to the common elements. Sometimes it extends to the condominium property, sometimes the common elements. Sometimes boards see they have rulemaking authority for the common elements and they implement lease restrictions through their rules and regulations. Maybe it's proper, maybe it's not, but it can cause issues. So you have to be mindful of the vulnerability to attack on a rule and regulation if it exceeds the scope set forth in those higher documents, the declaration, the bylaws, and the articles of incorporation. You know your board structure, you have your officers, you have your directors, you have your committees. Members of committees do not necessarily need to be on the board of directors itself. Often they are not. Sometimes members of committees are appointed by a president's unilateral appointment. Sometimes it is upon a board vote. But it is often as simple as the president gets to establish these committees and appoint members to them. The most common committees that we see are really legal committees, and then some in an HOA, an architectural control committee. But the legal committee is an important one because it allows us to have some attorney-client privilege communication without having a full-blown board meeting and necessarily involving a lot of people, because while you can have a confidential meeting with a full board of directors, good luck. Simple as that. When you have 7 directors in a room, oftentimes one of them doesn't agree with what the majority of the board is doing. You tend to have leaks. It does occur. 2 duties, duty of care and duty of loyalty. This is what your duty as members of the board of directors. I could go through every single detail here, but this is the question that I usually get.
To the left.
Michael, can I get sued as a member of the board of directors individually? The answer, first of all, is that you can get sued for anything. Pretty much takes a $400 filing fee and a trip to the courthouse. And unfortunately, in this day and age, a lot of lawsuits really need that level of really just unfortunate litigious nature. But there's 2 things to take away. For individual liability itself, fraud, self-dealing, unjust enrichment, or typically a willful failure to enforce your documents for your personal benefit. Stupidity, and I'm not saying that's anybody in this room, stupidity or poor business judgment is not something that can be used to establish individual liability. If you hire a contractor that screws the association, that happens. Now, unfortunately, all too much. It doesn't mean that you are going to be held individually liable for a mistake. The business judgment rule is also important because if somebody goes to court to try to stop you from hiring that contractor, I'm sorry, elections have consequences. We're not going to question the business judgment of people. If you're violating the law, that's one thing. But if you just think that going with XYZ contractor is better than going with ABC, you can't go to court and say, why are you going with the more expensive contractor? Well, you know what? I did it because I thought it was a good idea and they do a better job. Courts don't question business judgment as a general rule.
Kickbacks.
All right. What was that?
Kickbacks.
They got kickbacks, that's all.
Yeah. Conflicts of interest. I'm going to hand it over to Joel. Joel, you need some caffeine. Go.
Florida statute 718 has two conflicting conflict of interest rules right now. This is an outgrowth of what happened in 2017 when the Florida legislature started adopting the grand jury report, but they didn't actually know what they were what they were talking about with the condo context. So we have right now 718.112 2P, which basically says that if you have a service provider, or if you're related to a service provider within 3 degrees of consanguinity, I'll explain what that term means in a moment, but you cannot, the condominium cannot, period, cannot enter into an agreement to provide services. There's another statute, 718.3027, that says that you can provide goods or services if you go through the entire jumping through hoops, and I'll go through what those hoops are. So, what are those hoops? First, you have to disclose all relevant information regarding the transaction to the board of directors. 2/3 of the independent directors have to approve the transaction at that point. You can be in the room while that discussion is going on. At the next meeting of the members, you have to disclose that transaction one more time, and the contract may be canceled by a majority vote. Remember when I said don't have quorum at a meeting? One of the reasons not to have quorum.
Under an AC.
Doesn't say that there's a time frame on it. It could be 15 years from now. They could have that meeting and go back and cancel your contract. And if the contract is not disclosed, 20% of the voting interest at any given time can void the contract. So they can call a meeting and try to get the transaction canceled. Now, there are times, what's consanguinity? It's when you're related to somebody. And this is a chart that the Florida Bar has actually put together back in 2017 to help understand what the concept is. Basically, and this is in your package in the book, if you have a 3 next to it, or anything lower than a 3, those people are not going to be allowed to enter into a contract with the association. So here, everything up to your great-grandchildren, nieces and nephews, aunts and uncles, but first cousins are okay. So that gives you an idea of the break point of where you can enter into the contract. Now, what gets really confusing is what happens when you start marrying within your in-laws family, and it gets, these numbers get really weird. Yes, and we do have cases where that comes up where, at one time they were your first cousin, but because you married somebody else, they've now become your aunt or uncle. It gets super, super confusing.
A bigger issue in the northern part of the state, but.
Yes. We do have an office in Volusia County, so I'll just leave it at that. Now, kickbacks, this is very common, getting accused of. Again, we've had the situation where the president happens to get the new car right after entering into the painting contract. Usually it's because the contractor just really likes you guys and gives you something. So we'll get into more about kickbacks in a little bit, but keep in mind the appearance of impropriety. You're not supposed to accept anything from contractors, from vendors or anything. The pen, the booklet, that's one thing, the lunch, all those are exempted under Florida statute, but when we start giving you bigger things, those are bad. during a hurricane restoration project, we had one association where the board was accused of getting a kickback because the president's unit was the 18th unit finished out of over 800. Now, to me, that's not being a kickback, because if it was the first unit finished and you walked in and it was marble floors and gold-plated fixtures, that's one thing. But as Michael said, when we turned it over, it was a complete shell, so I don't take it that seriously.
Does this apply only to the board or to the property managers as well?
Property managers, there's a completely separate set of statutes on them. So
the property manager, can they hire their relative to do some work?
theoretically, yes. But they should, in all fairness to the board, disclose all their relationships on it. Yes, sir.
So if you sign, the board signs a 3-year contract, but then the next board comes in and wants to cancel it, they still have to live by the legal contract.
You would have to review the contracts, and every contract is different with that. Yes, it is.
Can property managers sell real estate on the side?
If they're properly licensed. They would have to have a regular real estate license if they're going to get a commission.
So you can be a property manager and sell real estate?
Yes. If they're properly, if they're licensed. Now, meetings. Normally your notice is 48 hours of all board meetings. There's 3 major exceptions. The major exceptions are budget meetings, which are 14 days. If you're doing any rule changes to affect the use of the unit, that's 14 days. And violation committees, which is a arguable area, but the case law out there is saying that you should give a separate 14-day notice of a board meeting to the member being fined in that particular case.
What about special assessment?
Special assessments 14, everything in the budget realm is 14 days. Agendas, as we discussed earlier, they should be detailed, they should have everything on it. Again, if you have a situation where you're not a chronic violator, occasionally you'll have old business and you carry it forward. I'm the secretary of my board, I make sure I enumerate every old business that can possibly come up and put it under there. You must allow members to speak for 3 minutes. Doesn't necessarily mean you have a right to reply or an obligation to reply. If they sit there and ask questions for 3 minutes, you can sit there at the board and say, thank you very much, and that's it. Interesting enough, there's nothing that says you even have to be in the room when we're asking the questions. So, think about it. Recording of a meeting.
That's why we're here.
You must allow unit owners to record the meeting. But the board can create rules regarding the recording. You can tell them to put a camera in certain occasions. That they can't be in front of you with their little cell phones recording everything. That the camera can make a lot of noise. There's an interesting case that I came across recently. I'm working on a project for the Florida Bar where we're taking all the declaratory statements. Believe it or not, nobody's ever created a full digest of all the declaratory statements the DBPR has ever issued. And I'm on the committee working on it, and I came across one on this issue that I thought was interesting. There's a co-op in the central part of the state that was a clothing optional co-op. But the board meetings were not clothing optional, if you know what I mean. One of the owners in the association wanted to record the meeting. Now the board members objected because you don't want everything to be out there necessarily. DBPR said, no, you have to allow the recording of the meeting, but the board should be smart enough to create some rules of modesty about where the camera is and with the proper camera angles. Now, I usually have a really bad joke about my association not wanting to be in a situation like this.
We're getting to the bad jokes now?
Yeah. Yes.
My question was, on what grounds or what are the conditions where a unit owner can have somebody else represent them at a meeting?
We have internal fights over this, Michael and I. I don't think the law is necessarily settled in this area. There's an old DBPR case that Michael brings up that says that if you have a power of attorney, you could show up at the meeting. I think that since the statute has been changed slightly, there is no Florida case on point interpreting the statute. There is a California case, and California has identical language to our statute, where the California court said, no, the power of attorney is not valid to show up at the meeting. So I think a court may rely on that California case, but it's a big open area right now. So we've been fighting back and forth internally on that.
So if a person shows up with a notarized letter saying they have the power of attorney to represent someone at a meeting, could it be more than one person? Or are the regulations like, why can't, if the person is not physically handicapped or the person understands the language, I can see no reason why that person himself cannot be at that meeting. Why should this person be entitled to a power of attorney?
My personal view is that I agree with the California court. That's rare for me to say that I agree with anything from a California court. That the statute says it's a members are entitled to show up. It does not say members or their representatives. There are some states like North Carolina that say members or their representatives. But again, Michael will argue with me on this at times and say, you know, there's this old DBPR case that says that power of attorney is good enough. And we're just waiting for where the chips fall.
Could they allow more than one person or just one person?
Again, we're waiting for the chips to fall. Because think about it this way, let's say, Michael, you hired our firm to represent you personally, and Michael and I show up to the meeting. We're both there because we represent different aspects of a claim that you may have against the board. Because Michael has his special areas, I have my special areas, and combined we happen to have, you're addressing both of those special areas. We could make the argument that we both should be there individually representing you, but then somebody like me on the other side will turn around and say, you know, thank you very much, get out. So it's still an open question. Let's put it that way. Tenants are, again, it's the same issue with the power of attorney.
But they're not generally allowed, there could make it just, you could potentially justify keeping them out without a power of attorney.
Yeah, that makes it's a lot easier with tenants. With minutes, as we discussed earlier, the best practices is very minimal. DBPR had a session for attorneys a few years ago about what should be in minutes. And they said it's the date and time of where you called the meeting, the board members who were attending the meeting, who made the motion to approve something, interestingly, not a second, and a listing of all the votes, of who voted for what, and that's it.
You don't have to say who seconded it.
Nope.
You do not have to. Under Robert's rules you do, but if you look at the Florida statute, it does not say that the second is necessarily the person.
Just a question, renters are allowed or not allowed?
I would generally say not allow them.
But it's not a big deal.
It depends on what's being discussed.
It's a big deal, because what the renters know that in the rules and regulation, but it's not anymore, because they don't have any rights because they're not the owner.
That's the question to you. We have unapproved meetings. Can you put them on the website and say they're not approved?
Yes, I normally put a big draft watermark on it.
Okay.
So, closed meetings. There's only 2 times you can have a closed meeting. One is if you have a meeting with your lawyer discussing pending or current or threatened litigation. If you're having a meeting with them to discuss the annual meeting, that is not something that is a legal meeting. That is a completely separate thing that should be noticed. Legal meetings should be actually noticed, but you can put on it that nobody's allowed to attend the meeting. And if you think you're going to be cute by like coming up with some fantasy of a possible threatened lawsuit, pretty good idea. If you want to close the meeting. Yes?
If you have 4 directors in the office discussing something, could that be held against you?
Maybe. We'll get into that in a second.
Any other questions?
Personnel matters. If you are discussing actual employees of the association, those meetings can be held to be confidential as well and closed. Now, the question is, that always comes up, what about the property manager? What happens if they're an independent contractor? What happens if we're discussing the employees of an independent contractor? That's a big question. We're still waiting on the answers on that. Now, parliamentary authority, we discussed Robert's rules. This is the original 1968 version. You can see that it's a little torn up. I sometimes get violent at meetings as parliamentarian, and I literally throw the book at people. This is probably more boring than my book on the course. And it doesn't work in today's condominium concept. For example, one of the things that Robert's Rules allows you to do, if you have a member that gets out of line, you can have a motion to instruct the sergeant of arms, because I'm sure everybody here is a sergeant of arms in their condo, to bind and gag the person. Yeah. From the laughter, I can imagine the number of lawsuits. The other big area that Robert's Rules fails at, I see, is, you know those rules from, 10 years ago that the board has, and you want to make a change to them? Yeah. Technically, under Robert's Rules, you've got to find somebody who actually voted for those rules, and they have to make a motion for reconsideration. And then you vote on the motion of reconsideration, then you can discuss the rule change. That's how bad Robert's Rules gets. I was a parliamentarian going way back to high school, so I unfortunately see with this. What I necessarily go with is Sturgis's Standard Code of Parliamentary Procedure. Much simpler, much more modern. It's actually, you can actually read it and not fall asleep sometimes. But it's a lot more modern. It's up to date on what normally goes on in the real world today. It's Sturgis's Standard Code of Parliamentary Procedure. It's the second most common used source of parliamentary authority. Now, trivia. What is the largest HOA in the United States?
The villages.
Close.
What is it, what?
The villages.
Century villages, yes.
No,
No?
villages is still closer, but. Association of Poinciana Villages.
Geographic area.
Geographic area, 47,000 acres.
Wow.
One HOA, 47,000 acres. Now, what is the largest HOA by the number of residents?
Well, that would be the villages.
The villages. 125,000 people in the villages. Now, what is the largest HOA conservation area? And by this I mean the most parks dedicated by the HOA. You know, when you have a little park area. And this is an association near and dear to Michael for a completely different reason. Vieira, Florida. 7,750 acres. And the reason why this is near and dear to Michael, when we took our certification exam, the last essay question, which basically freaked everybody out, was to recreate Vieira, Florida, and list every single legal issue that will ever possibly come up on this. And Michael is mad at me to this day because I was at a conference with the guy who wrote the essay question, where the guy introduced the people who did Vieira, Florida, and said, don't be surprised if this will pop up on the certification exam. And I didn't tell Michael. I was surprised too because I completely forgot about it 5 minutes after her presentation. So now, do you want to take over insurance?
All right, we touched on condo insurance, and again, I'm going to go at warp speed a little bit just because I really don't want to hold anyone late. Stop me if you'd like to, and I'll talk after as long as people want. Association must use its best efforts to obtain and maintain adequate insurance. What is adequate insurance? The association's policy to cover you for, and the building as originally constructed with certain exclusions. These are the exclusions. The things you typically see are the floor, wall, and ceiling covering, electrical fixtures. If somebody has a chandelier, that's not on the association's insurance, Water heaters, built-in cabinets, your kitchen counters, window treatments, the items added to a substantial sum of money, drapes, blinds, other types of hardware. These are things that are on the unit owner. Now, is it the unit owner's requirement to maintain insurance? Really good question. There's an opinion out there, a declaratory statement called Plaza East, that suggests it may be required. But you know what? I'm not convinced. And that's an old opinion, and I haven't seen any appellate courts uphold it. So here's what I'll tell you. I think every association should strongly consider mandating HO6 unit owner policies, because the statute's clear that the association has to use its best efforts to get insurance, but what about the owner? It's not clearly mandatory, and in a lot of condominiums, they do not have it. I hate these situations, because when you get into a mystery of a water leak, it's terrible, because honestly, most of the time, it's not some sort of really patent negligence where somebody saw the pipe leaking and they ignored it and then it burst open after 6 months of drip, 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 and they could have stopped it. Usually it's innocent mistakes, usually, not always. And when it's an innocent mistake, it's better to have insurance involved. It's like getting in a car and driving on the highway today. You know, when we're all on this roadway together, everyone should have insurance. If something happens, let the insurance companies fight about it. I recommend mandatory HO6 insurance, but it is not in the statute. Yes, ma'am.
What about individual units within a condominium that doesn't have hot water? Whose responsibility is that?
Where you're saying where there's a water heater that's like a main water heater for these.
They don't have hot water in the kitchen faucet. Whose responsibility is it? Individual owners or?
I don't know what the cause is of why they're not getting the hot water. You'd have to isolate that and then. If it's
The question about we can't hear.
yeah, if the hot water heater inside the unit does not work, that's on the unit owner. Probably the unit owner. Probably the unit owner, yeah. Correct. Correct.
How do you implement the mandatory insurance?
You have to amend your governing documents. You have to amend your declaration of condominium, is what I would do.
Notice was that the person, before he goes, damages the leaks. I thought the property with the water situation saying that the individual downstairs can sue upstairs.
It depends on the details. If they did something wrong upstairs, I still think there's a private right of action. And by the way, another special tool, if a unit owner causes damage to the common elements and the claim is submitted to insurance and the association is not made whole, typically it's the deductible, it could be more than that, you have the power to specially assess the owner that caused the incident if they were negligent or failed to comply with their maintenance responsibilities. For instance, if their water heater was beyond its useful life, it bursts, it causes a flood that cascades downstairs, you could actually specially assess the owner that was responsible for that water heater. And that owner only. It's a special provision of 718.111. J2. It can be. How do you define spontaneous?
Now they're trying to think about
Because then you're not negligent to maintain. It can be a different situation. Exactly. All right. And opt out and do self-insurance as a condominium. There is a process for that. I'm going to just say, I don't even want to talk about it. You're crazy if you do it. That you are just biting off an enormous array of problems that could arise. The liability would be enormous. I don't want to hear that you're doing it.
From
We're
what?
talking about like consolidation.
We can hear here.
Self-insurance, meaning I'm not going to get a property damage policy, and if hurricane whatever comes through and destroys our property, the owners are just going to get specially assessed to reconstruct. That's the nightmare scenario that I'm talking about. You don't want to self-insure and be responsible for your own casualty losses. I at least strongly discourage it. Very costly.
And to put it more in context, since this came in 2008, there's only been 3 condos that have attempted to do a self-insurance, and because you have to apply to the Department of Insurance regulation in order to get approval on doing a self-insurance, the Department of Insurance regulation turned them down, saying, you guys don't know what you're doing, stay out of the insurance field. It's a completely separate business. You're in the process of managing your association elements in your building. You're not in the process of doing actuarial calculations.
What about the 36 months requirement for reassess property value?
Oh, you're talking about for reserve studies?
No. Yeah, maybe, but I saw it's insurance, 36.
Yeah,
They
you're-
require
Yeah.
Okay.
every 3 years.
Yes. You are required every 30, give or take 36 months. I don't think it's you're too much of a hard line on it, but you are supposed to go in and determine the value of the property and take a look at your insurance and whether every 36 months and get that study, give it to your insurance agent usually gets it for you, and they give it to the insurance company.
Insurance versus maintenance. This is something to keep in mind. Just because something is an insurance responsibility of the association does not mean that it is a maintenance responsibility of the association. For instance, I talked about how the casualty policies must include the drywall on the unit. I have associations that instead of delineating that it is the association responsible for the drywall, it actually says that the owner is responsible for everything if you drew an imaginary line between the two drywalls of the neighboring units. So if you have two walls, you have an imaginary line right down the middle, the owner is actually responsible for the maintenance of the drywall. But in the instance of a casualty event, the association still insures it. So you have to look, there's separate provisions in your declaration for maintenance and insurance. Again, insurance largely is statutorily driven, so you might almost want to ignore those provisions in your declaration, but maintenance is driven by your documents, and you have to look to that specifically, regardless of insurance requirements. They're two independent concepts.
The drains, and the seal,
Go ahead, clean up.
leaks, damages underneath. We have to fix them, don't we?
Take a look at where your parametrical boundaries are. The shower pan is one of the issues that we have come up all the time, whether or not it's inside the unit or outside the unit. It gets really
And what about
convoluted.
the drain? There's the drain from the bathtub. That's
It depends on your governing documents.
Sometimes it can be like an imaginary line in the middle of the slab. Sometimes it's where it emerges from the slab. This is why I like to have insurance involved, because the amount of time I see my associations spend a lot of money trying to figure these things out, only to realize they're chasing a ghost that it's just not clear. I'd rather let the insurance companies fight it out. So if you get mandatory owner insurance in there, hands off, submit your insurance claim, and you pay a deductible, and then you move on with life. And if it's a clear instance where you feel like somebody did something wrong to get you into that insurance claim situation, you specially assess for the deductible. Just to keep it simple. Right of access to unit. A condominium association has an irrevocable right of access into every single condominium unit in order to maintain, repair, and replace the common elements. If the association is responsible for the drywall and you refuse to let them into the unit, then how the heck are we supposed to maintain it? We can't, magically take care of something that requires direct unit access. So we do have that irrevocable right of access. You should be reasonable in yielding it. If somebody's giving you a hard time, tell them, give them a, depending on how emergent the situation is, give them 24, 48, 72 hours notice. Hopefully they cooperate. If they don't, send them a letter from maybe a law firm, and hopefully that will do it as well. Yes, sir.
What if you think and have been advised that one of the units is in violation, and claim something that is in violation?
I think that could potentially pose a threat to the common elements, so I think you could justify it.
What about pest control, exterminators?
It can also pose, because these things, water, pest control, fire hazard, these are things that pose a threat to the whole building, including the common elements. So I think it's part of the maintenance function.
What is the process of assessing individual units?
For, you're saying with the insurance scenario I described,
Yeah.
you have to go through the normal special assessment process, except you target it at a particular unit owner.
So it's the meeting and notice?
14 days notice, all that fun stuff, yeah.
Open to the public.
Open to the public. Yep. Yes,
So if
ma'am.
there's a concern that something's happening from a unit, we could just go right in, because my president said we have to have their permission, and sometimes we really had to wait.
This is why, so the answer is yes, you legally have an irrevocable right of access and you can just go in. But as a practical matter, there's and this is not, again, not political, there's 400 million guns in this country. Imagine just going and barging into unit owners' apartments without a warrant. It's, you could walk into a dangerous situation, so you want to communicate.
They're not around, we know they're not around, they can't be reached right away, and something's going on, sometimes we're trying to get them.
If there's water flowing under the door and you know there's nobody inside that unit, and you can get in that unit, I'm okay with it if you have the ability to get in without damaging the unit.
don't have to notify and stuff.
Right. In an emergency, you don't have to notify. If it's not an emergency, you do.
Are we required to have access to all the units, or does that just, it's in our documents?
It depends on your governing documents. If you're, I know several of our associations have a requirement that you have to give a building management a copy of your key. That's one thing. If it's not in there, you can possibly pass a rule that says we need to have access, provide a key. That may be upheld, and I've seen some cases that have upheld it as being reasonable.
First of all, fire rescue is allowed to come in on emergency and break the door down.
Yep.
Abandoned, does that say
The next concept of irrevocable right of access, abandonment. This is another amendment to the statute that came about after the foreclosure crisis. What the issue was in that instance is you had a lot of people that just walked away from their unit. Sometimes they had a tenant in there, a lot of times they did not. They just realized the time had passed for them to live in that place, they couldn't afford it, and they had to move on with their lives for X, Y, and Z reasons. When you have an abandoned unit that is subject to a foreclosure action, there's specifics here. Subject to a foreclosure action, no tenant within the past 4 weeks, then without notice you can go in there, and if there's anything that you need to do to maintain that property in order to avoid damage to the common elements, you can assess that unit for whatever maintenance efforts you perform. If it is not in foreclosure and there has been no tenant for 2 months, you have to attempt to contact the unit owner, otherwise you can go in and you can start taking over the maintenance of that unit, and meaning the interior contents. The things like the kitchen cabinets, if there's mold, if things need to be ripped out because there's a mold situation, you can do that. If there's a mattress that's infested with some sort of insects, you can get rid of that and you can charge your costs like an assessment and get a lien on the property. But in these instances, you have to make sure you go through your checklist. Is it in a foreclosure? Yes, no. No, it's not. Then you need to have a little bit more of a longer period of time of 2 months with no tenants. And then you have to attempt to contact the unit owner. If you follow your process, though, you can take care of the situation when you have an unresponsive owner.
What if it's involved in litigation?
Loan litigation?
Well, in litigation.
Oh, litigation. What kind of, that wouldn't be relevant to, other than if it's
There
a...
are people fighting over the title and whatever, but in the meantime, it's for 6 years. Pretty much empty.
So if they respond to you when in a situation where they're not in foreclosure, then they've done what they have to do, meaning they block you basically as an association. But if you are in foreclosure, and again, you are in foreclosure, no tenant within the last 4 weeks, then you can just go in and take care of the situation. Yes, ma'am.
I just want to know, is this in the booklet we were handed out, that was handed out?
Yes, look for abandonment as the concept.
Abandonment, okay, thank you very much.
Yes. Amendments to the governing documents, okay. Generally, it's a 2/3 vote of all owners in the association. All owners, as opposed to those just present at a quorum meeting of the owners. It varies based upon governing documents, though, unless, of course, your documents are silent, then you default to the statute. So let's assume it's 2/3. If it's a 2/3 vote, you have 100 units in your condominium, you need 67 people to vote in favor of the amendment for it to pass. Once the amendment passes, it should, and when it's presented actually, you need to present it in a very specific way. Any changes that you make have to be underlined if you're adding language, and if you're deleting language, you have to have a strike through. If you don't present the vote the proper way, and you don't record it the proper way in public records, it is not a valid amendment. And it does not take effect until it is actually recorded in public records. So be warned that if you have a successful vote, but your attorney or you forget to file the recorded amendment for a couple months, if there's a violation in between, the amendment's not technically effective until it is recorded in Dade County or Broward County public records, wherever you might be. Other critical votes that you will see: material alterations. Anything that palpably affects the color, use, form, or appearance of the condominium property can require a vote of the owners to change. This is an absolute nightmare for condominiums. And I call it a nightmare because while I certainly respect that everyone buys into a certain concept, it can become a nightmare in the sense that your condominium becomes a time capsule. If you want to get rid of the Art Deco theme that the developer thought was a great idea in 1992, and you want to go to something more modern, but you have unit owners that, like the gentleman said back there, maybe live overseas and aren't very participating, you can struggle to get that vote, and you're stuck in this time capsule. So what's really scary about it, though, is the division has gone so far as to call some very nominal things material alterations. Changing the color of the cushions in the lobby can be a material alteration. I'm talking like $7,500 projects could potentially trigger a material alteration vote by a literal reading of the law.
What happens if your docs say $100,000, maybe otherwise huge loss?
Great language to include in your governing documents.
Okay.
And I have lots of clients that have it.
Could you
It's a-
repeat that? I didn't-
You can have language in your governing document that says you're only required to get a material alteration vote if you cross a certain dollar threshold. The lady mentioned an example of if you spend more than $100,000 on the material alteration, then you need a membership vote. But if you're gonna spend $50,000, then you don't need a membership vote, the board can just make the decision.
And what would be a common suggestion for what that amount should be?
Depends on your association.
It's the sensibilities of the community a lot of the time. You know, if you're an association that regularly is engaging in $50,000, $75,000 dollar expenditures, then in that instance, then maybe $100,000 is a good number. But if you're a community where a $75,000 line item, maybe you're a 10-unit condominium, that's $7,500 of everybody's money. So that's something that maybe you're not as comfortable with authorizing $75,000. It goes to the particulars of the community usually. All right, you do need to send out copies to the members of the amendments, and ultimately you should notify them afterward of the passage of the amendments. Rentals are a unique animal, and for condominiums specifically. There was a case called Woodside that came out years ago, another Florida Supremes case. And what happened in Woodside is an investor bought into a condominium. The condominium started to regulate the duration and frequency of rentals. Things like you can only rent 2 times per year. You have to rent for at least 30 days or more. Things like that. And the documents were amended pursuant to a valid unit owner vote. And in response to that, the investor brought a lawsuit and said, this is my property. I bought this as an investment property. Who the heck are you to gut my investment and leave me in a situation where I can't use it the way that I wanted to? You know what the Florida Supreme said? Sorry, investor, you also bought into a contract, your declaration. You see the theme now. That contract had an amendment provision. So if you had a valid amendment, then that valid amendment is binding upon you. That was part of the deal as well. So while you may have thought, okay, these are the leasing protocols when I bought, you also had that amendment provision, and the two go together. So you're bound by it. So what happened? Florida legislature, obviously wanting to make real estate as appealing as possible for investors, because that does drive up our real property values, it's a reality. 718-11013. Any amendment that affects the duration or frequency of rentals is not binding on a unit owner that does not vote yes. That means if you vote no or if you don't vote at all and the amendment still passes, you are not bound by it. Now, when
October 1st, 2004.
After October 1st, 2004, absolutely. That's when this all came into effect. It was a reaction to Woodside. That's the Florida Supreme Court case. Now, when let's say I vote no or I don't vote at all. When I sell the property to a third party, they are bound by the amendment. But for the duration of their ownership, if they vote no or they don't vote at all, they are not bound by the amendment. Why is this a big issue? How many people in this room have an issue with Airbnb in their community?
Oh, yeah.
This along with emotional support animals, these are the hot button issues we hear about every day. Airbnb can be a great thing for investors, it can be an epidemic on communities because at the end of the day, there tends to be an inverse relationship. The shorter the duration of the stay, the less, actually I guess it's a direct relationship. Shorter the stay, the less they care about your property. If somebody's staying there for a year, they're probably going to be a little more of an honorable tenant than if they're there for a weekend vacation with the rest of their fraternity brothers.
What's the best way to deal with short-term rentals like that?
You can amend your documents and you gotta hope that people vote yes. If you have behavioral issues, you can still deal with those through other mechanisms. But to block them, you can fine people and use other types of mechanisms to enforce it. But at the end of the day, that's only if there's a behavioral issue. If you want to block Airbnb itself, condos are in a tough place right now.
How do you find people? Can you, do you have to prove it somehow that?
We'll get to the grievance committee. We're gonna get to that in a little bit. And I'm gonna try, maybe not. I'm gonna try to go fast again. Help me out, guys.
On the rentals, is there a limit to how many apartments somebody can purchase to rent, let's say,
It depends on your documents. If you have a declaration provision that prohibits it, you can do it. Okay, I'm gonna go real fast now because we're at 150 right now. Okay. Contracts, the big thing you need to know is that if it gets over 5%, you have to bid it. That's the big thing, and that's the magic number. 5% of your annual budget, you should be going out for bidding. We're not in an HOA, we'll skip these cartoons, keep going, as funny as we are. We talked about rules and regs. Make sure you're acting within your authority, and from there, you want to make sure you're acting in good faith. Don't be arbitrary. Don't be selective. That's a defense. Even if somebody's breaking the rule, you better make sure that you're enforcing that rule uniformly across the property. Otherwise, you can't enforce it in a specific instance. If you've been failing to enforce it unilaterally, put out a notice to your community saying, community, we haven't been enforcing this provision that says no bottles at the pool area. Please be advised we will be strictly enforcing it going forward. By putting the world on notice, you can revive the rule. That's how you handle that situation, or maybe passports warrant as vehement. And if you really have an issue with your management company, considering hiring Campbell Property Management, because they won't make that mistake. Okay. Fines and violations, I want to emphasize this one as well. The grievance committee is an incredible tool. I said to you, I would teach you things that will save you money and result in you paying me less. The grievance committee should be used far more than it is by most of my communities. Most of the time, they just haven't taken the time to solidify the process. But the Condominium Act allows you to establish a grievance committee comprised of 3 people not related to the board, at least 3 people. The board of directors has the power to vote to impose fines or suspension. The fine can be $100 per day the violation exists, for a maximum of $1,000. The suspension can be fun stuff if, for instance, you have a guard gate, you can make them go through the visitor's entrance. I've had litigation where people spend tens and tens of thousands of dollars in legal fees fighting over pretty nominal stuff. In one instance, there was a dock and somebody wanted to have a jet ski float where you can drive your jet ski up onto it as a method of dry storage. It was against the rules. The guy fought us tooth and nail. We made his wife go through the visitor's entrance for 1 day, and he called to say he'd take the jet ski float out of the water. So making people have to drive through the visitor entrance of their own community is an incredibly powerful tool. You can suspend use of anything that's a non-essential, non-utility type service. In this day and age, I think that does include internet. It does certainly include that you cannot suspend things like trash pickup, but you can suspend access to other common elements. If you have a key fob for the pool area or the gym, you can suspend that as well.
Do the 3 people have to be, could they be hidden?
No, you have to have 3 people, and the process is the board has to impose the fine or suspension, you have to provide written notice, and then you have to give 14 days notice to the grievance committee, who can uphold or reject the fine or suspension. They can't modify it, uphold or reject. And I'm sorry I'm going fast, guys, but I really want to blow through this for you, and I'll stick around afterward. Records maintenance. Generally, you want to maintain everything for 7 years, election records for 1 year, minutes now are for forever. You want to maintain these records because there can be civil penalties, and we even talked about the possibility of a criminal penalty. We also now have a website requirement, effective Jan 1, 2019. If you have more than 150 units, you need to have a lot of your official records on there as well. There's a checklist in 718 of what's required on the website. When you get to that point in time, you should go through that checklist and use your reference materials. Also be warned about disability compliance for the visually impaired. There are predatory groups out there that are suing condominium associations because their website is not disability compliant for people that have different types of visual impairments. Obviously a serious issue if you are visually impaired, but there are genuinely predatory organizations out there going around suing our clients right now for this. They get their attorney's fees, that's the gist of it. All right, here's the list of the condominium records and what you have to maintain. Again, it's in your books. We're going to skip case studies. Website we talked about, 150 units or more. These are the website requirements. It's dense stuff. It's in your reference materials. Records requests from owners. If an owner submits a records request in writing, you have to make the records available for inspection within 10 days. In writing is how the request must be submitted according to the division, unless you make the, I'm going to call it, mistake of indulging a different type of request. If somebody sends an email records request and you respond or acknowledge receipt of it, you could be bound to respond to that records request. What we recommend is a strict protocol implemented through a written resolution of the board that says all records requests must be in writing. Otherwise, your property manager is going to be living a nightmare where every unit owner just has to go onto their iPhone and hit send at the end of the night, and then they put you on a 10-day ticking clock. Making somebody put something in writing really makes them have to care about the issue a lot more before they start just putting a wrench into your day-to-day operations. That's records requests, and you have to make them available for inspection. You don't have to give them copies. They can pay for copies. They can take pictures on their phone of the records. Written inquiries is another thing they can do. This is that owners can submit written questions to the board of directors. They must be submitted by certified mail, and you have to respond within 30 days thereof. If you refer the matter to your legal counsel, you get another 30 days for a total of 60 days. And at the end, and you need to respond to these things by law. They can ask, there are limitations sometimes on what you might provide in your response. You can certainly question when they start to get into things that maybe involve attorney-client privilege, but you have to respond to these written inquiries when they're presented by certified mail. Yes?
If we get a complaint by email, we don't have to answer it?
No.
You just made her dead.
You want to get 200 emails from this board?
If you don't respond, the penalty for not responding is that if you get sued over it, you can, and you're successful as the association, you cannot collect attorney's fees.
Okay, and we're now moving into the lightning round at 1:56 p.m. Budgets. You have your annual budget meeting when you should be adopting your budget, and the big issue that's going to come up there, and I'm going to flip through the slide when I get to it, so we'll do it right now. Reserves. That's the big issue. Do you have to fully fund reserves? The default is yes. Unless you get a unit owner vote, you need to fully fund your reserves. Now, does that mean I have to fully fund to the most expensive method possible? No. You have two options. You have the straight line method, and that generally means something if I have a $100,000 roof and it has a $25 useful life, I should be collecting $4,000 per year in order to pay for that roof replacement at the end of the 25 years. That's the straight line method. The board can vote to switch to the pooling method. The pooling method, it gets a little complicated, but it's about cash flows and having enough on hand to maintain your accounts through the course of the year with what's going to come due. The nice thing is under the pooling method, without getting into the math of it, the annual contribution is less. I have an association that switched to the pooling method and the reserve contribution dropped by like 40%. And you can do that upon a simple board vote. But if you want to partially fund reserves or waive the funding in reserves, that requires a majority vote of the owners at a meeting with a quorum present.
But the other portion of it is that there's a belief out there that you must give the owners the opportunity to waive reserves. If you as a board want to fully fund reserves, there is no obligation to go to the unit owners to have that vote. And even if the unit owners come up and say, here, we took our vote ourselves, you can ignore that. The board always has the option to go to a fully funded reserve.
So you don't have to have an option to waive reserves?
Right.
That's correct? Okay, that's legal.
These are the categories of reserves. Basically, everything under over $10,000 for replacement has to be within your reserve study. The big ones are typically roofs, painting, and pavement. But anything over $10,000 should be thrown into your reserve computation. This is just taking you through the straight line method, the exact scenario I described: 100 grand, 25 years, 4,000 a year contribution. Pooling method, we'll spare you on that. It's all in the book, and yes, and I'm sorry we're going fast, but we're just, not everyone wants to be here for 4 hours as much as I like to hear myself speak. Collections, this is a major issue, and you should be treating it not in a robotic manner to some degree. I think associations should be robotic in that when you become a certain amount delinquent, it should be referred to collections. But in the decision about filing your initial demand letter, you have a 3-step process: collection letter, lien, foreclosed, 30 days, 30 days, 30 days. I think the collection letter and lien letter you should pretty much always be doing when somebody becomes delinquent. But that decision to foreclose, please don't get yourself into a situation where somebody is just telling you as an association, go forward no matter what. You need to pay attention whether there's bankruptcies out there, bank foreclosures out there. You may spend $3,000, $4,000, $5,000, $6,000 on attorney's fees only for the bank to foreclose the day after you complete your process, and they wipe out the entire balance. So a bank, when they finish foreclosing, may not be responsible for whatever assessments have accrued or whatever attorney's fees you run up. So if you know the bank's about to complete the process, let them finish the process. Don't spend the association's money on lawyers to foreclose in a process that will be meaningless because the bank is just about to do the job for you. You should really look at it on a case-by-case basis. Foreclosure process, we talked about that. Metropolitan, here's some fun trivia that's actually relevant. What metropolitan area has the largest percentage of population served by mutual aid condos? Broward, right here. After that, Palm Beach County, Miami-Dade County. Remember I said that we're at the epicenter of planned communities here in Florida? The Tri-County area is winning. I'm going to skip past that. We had the largest HOA assessment in there. We can't use that trivia question anymore because now we represent them. 32 parcels of land. The average property is between $5 and $25 million. It's a really special community with owners of baseball franchises and all sorts of fun stuff. It's a lot. It's thousands a month, many thousands. Like I think it's like 15,000 a month.
No amenities.
Card gate. The other collection tool to know about, the rent demand letter. If an owner is delinquent in assessments and they have a tenant in the unit, you can step into the shoes of the landlord. The tenant is immune from eviction for not paying the landlord directly. They have to pay the association until the account is brought current. We'll skip ADR. While Joel's getting us to the last slide, Thelma's handing out your certificates right now. Thelma Fernandez is a wonderful resource at the firm if you get the chance to work with us. She is bilingual, and she is incredible when it comes to collections, foreclosures, and general counsel services for condo associations. If you adopt the rights protocol, yes, you can. With tenants, it's a little tougher because the thing I worry about is the tenant has a limited financial responsibility to the association. So why should we care? The reason why I can justify it is because of the rent demand letter. If theoretically the tenant is the guarantor of the assessments, then I feel like I can say the credit score matters. But sometimes people say, what the heck do you care, association, about the credit score? The owner's responsible for the maintenance. That's the issue. But I think you could justify it if you wanted to. I think. All right. Everybody, it's 2 o'clock. I turned into a pumpkin right now.
Guys, hold on for 1 second. Hold on 1 second. You waited this long. Hold on. Yes? No?
You go for it, sir. Absolutely.
Go for it. I'm closing the door so you can't get out. All right. First of all, how good were these guys here? All right, for beginners they're good, and for those of you that diplomatically answered your questions, as I said before, not to be specific, in a roundabout way, you got your free legal advice, right?
Yes.
Okay, so they're here to answer any questions. Before you get up, hold on, 2 things. If you remember, at the beginning of the meeting, don't step there, there's a fork. Now, here was a great question. The young lady handed these out. One of the questions were in the back by the gentleman there sitting next to me. He said, what about a date, because they're asked to when they took the class. So if you want them to write their names in and just date it.
If they want to put in a date, they are more than welcome to.
Is that your question? Got it. Took care of my guy back there sitting next to me. Second thing is, you do have this evaluation. This is really important to us. It really is. You guys came out today, you gave your time, but it's really important for us as Campbell Property Management to know how we did and what's beneficial to you, so we can, in the very near future, invite you back for another free lunch. Does that sound good? Okay.
Good idea.
That's number 2. Wait a minute. My friend back there, quiet. Here's the other thing. Even after that, even after you got dessert first, dinner, breakfast second, whatever, lunch second, remember, fill this out. This is your chance to win the $50 American Express card.
I got it last time.
See that? What the hell are you doing back here again? Good thing she knows me. All right, so there is, when you go out this door, when you go out the door right here where Ashley and Diego are sitting, there's a little box there, plastic box with a little slit in the top. Drop it in there. Some of you collected them, some of we got it, and we got it. Last thing, you got this. Evan mentioned it. Evan mentioned it, as I said to you in the very beginning when I first spoke. This piece of paper that you have on your table. Second page is what Evan said about the fan, right? Florida Association News. Go on, take your time. I know Evan gave it the website. Some of you I saw write it down from the back. But the information is right here. Right on. Sign up. When you have a chance, go on, log on. Take you all of 15 seconds. And you'll get all kinds of update and education that you have. My last thing, some of you in here are my neighbors. I live in a neighborhood. I would be remiss if I didn't do this. I would be remiss if I didn't do this. Move, sir. Who are we?
Campbell Property.
Thank you. The lady who won the last $50 American Express. There you go. I know her forever. We are the oldest property management, family-owned property management company in the state of Florida since what does it say? 1953, that's not on there, it's up, there it is. At the top. Since 1953, third generation. Bill Campbell is the grandson of the original founders. We believe in service, we believe in taking care of our customers. I know you're all in here, I know many of your associations. Where's my friends from Point East? You guys don't remember, some of you do if you did when I ran for city commission there. Ah, there she is, right there. Did you vote for me? You only voted once though?
Loaded question.
You gotta remember what state we're in. You guys have to learn the rules here, okay? All right, listen, my cards are outside. I am in your neighborhood. I am your advocate. I am on the Florida Community Regulatory Council for Community Associations under the Department of Business and Professional Regulation. So besides all that, I am your advocate for associations. Take my card. Anytime you have a question, call me. Anything we can do from Campbell Property Management, give us a call, let us know. Thank you for coming, and I hope you enjoy lunch.
Thank you.